Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul. I will guide you on this 3-hour journey through Courtlandia. We start in Michigan, Judge Middleton.
Is this my cheat sheet? Who is it? Cottrell?
Yes.
He's not here.
He's not here.
Well, we'll see. All right, thanks. Good morning, Mr. Sharma. You got a ticket for driving without a valid operator's license. Let's take a look at this. Wrong case. The ticket was in the village of White Pigeon. You own the store in Mendon, don't you?
Yes,
You and your brother?
yes, you know.
Good morning. Well, they allege that you were in Mendon, in White Pigeon on May 30th, and you were driving without having a license ever acquired. No license ever acquired is one variety of not having a license. It's punishable by up to 90 days in jail and a fine of up to $500. One point, they said you lived in Mount Pleasant, and there's a big red warning on here. The name does not match the date of birth. But you do have an ID, but not a license. So the allegation is you were driving that day without having a license in the village of White Pigeon. The gentleman seated next to you is Mr. Stickley. He's the chief public defender. If you plead to this charge, I'm going to give you a fine, but it will go on your driving record and perhaps make it harder for you to get a license. Do you understand?
Yes, you know.
If you have an ID, you must have lawful residency status or citizenship. So that isn't an issue, but this could affect your ability to get a license. How do you plead to that charge?
You know, I have international driving license and I am sorry for my mistake.
Do you have your international license with you?
Yes, you know.
All right. May I see it? It's very difficult to get an international driver's license, but I have seen a number of people from India actually get one. Did you show that to the officer?
Yes, you know.
Your Honor, he does have an international driver's license, the translation card. And it appears he does have a valid driver's license from India, so. I don't think he's representing the international driver's license is the license. I think he's trying to do it properly and say that it's the translation card.
Yes. The translation card says no usable data found. And the other one doesn't come back with anything. And that doesn't mean it isn't accurate, it just doesn't, I don't know about that. This is a White Pigeon case, and I think White Pigeon is actually scheduled to be here today for some pre-trials. I think I have, Dylan Penn and Amber Carpenter, I think, are White Pigeon cases. So have a seat for a minute, sir. Let me hold on to these for a minute. And I think the White Pigeon village attorney may be here. Would you guys check and see if anybody's here from White Pigeon? Have a seat for a minute. We'll come back to your case. It's an interesting circumstance. I'm not sure exactly what we got. Mary Bakarowski. Good morning, gentlemen.
Good morning.
Could you take off your hat? Yeah, thank you. Good morning.
Good morning.
All right. You got a ticket on May 28th in Center on Three Rivers. This would be Mr. George, who just left, leaving the scene of a property damage accident, drove into the fence and almost into the river. Officers had to find the driver at 120 River Drive and bring her back to the accident. Do you still live here in Centerville?
Yes, I do. I was driving, well, when you asked me.
Well, this one is 618. I think it carries 2 points. Perhaps Mr. George might be willing to amend it to fixtures or something, which wouldn't carry any points.
I'd ask them to wait till he come back, or at least enter a not guilty plea for now, see if we can talk to Mr. George and see if we work.
Yes, Ms. Bakarowski, let's take a look at your driving record. I think you're clear. Valid. Yeah, you got essentially nothing on here. All right, you got really nothing. You have no points. You've never had any points. That I can see. So have a seat for a minute. We'll wait for the Three River City Attorney to come back and see if he can help us.
Okay, thank you.
Good morning once again, everybody. It's TCF Live on a Tuesday morning that, at least from this channel's perspective, is trying to turn into a Monday number 2. For whatever reason, YouTube's being a little bit glitchy again this morning. It is not showing us as being a channel that's live at the moment, which means we're not showing up in everybody's live feeds. So we'll see how this goes. But for those of you who have found us, good morning and thank you for joining us. And feel free to go knock on your neighbors' doors and tell them to tune in, because I think unless they fix this, we might struggle for views today. Anywho, let's stay in Michigan, but let's go say good morning to Judge Oakley.
Appearance, please.
Good morning, Alex Hill, P76961 on behalf of Tyler Ouellette, who's present on Zoom, consents to Zoom. Sir, will you state your name for the record, please?
Tyler Michael Ouellette.
Thank you, Mr. Ouellette. Counsel, I understand there's a waiver.
Correct, Your Honor. We are asking that this matter be waived and bound over to circuit court. My client understands his rights to have a preliminary exam, and he's knowingly waiving those at this time.
All right, Mr. Ouellette, true, you understand your rights and the options those rights give you.
Yes, sir.
You understand the purpose for the preliminary exam.
Yes, sir.
You understand a waiver means the file goes downtown for your next court date, not at the district court level where I'm at.
Yes, sir.
Understanding all of this, are you waiving the exam, your right to an exam today freely and voluntarily?
Yes, sir.
And counsel, are you satisfied with the waiver?
Satisfied, Your Honor.
All right, I'll enter the waiver. AOI date is going to be 2 weeks from today, 9 a.m. Anything else, gentlemen?
Nothing further on this record, Your Honor, but I'll see you in a little while on Mr. Schomer.
All right, bond will be continued. Good luck downtown, Mr. Ouellette.
Thank you, sir.
Mr. Hill, you do know that Mr. Schomer is going to be on Zoom.
Yeah, I'm aware. He's got a 12 o'clock PSI interview too, so I'm going to head down and meet with him. I don't think I'm going to be on jail from Zoom. I'm going to just make it back to the office, but I got to go chat with him.
Okay, yep, perfect. Thanks.
Thank you. You can log off, Mr. Ouellette.
Good morning, Mr. King. How are you?
Oh, I'm doing well, Judge. How are you?
Much better than I deserve, Larry.
Yeah, I'm just next door in the conference room. If you need anything, I'm covering for Mr. Leckie today.
Thank you. You guys let him go on vacation?
No, he got hauled over to something at Third Circuit that we thought was going to resolve, but it didn't. And then Trish was supposed to come out here and she got tied up with something. So I got, drafted in at the last minute, but I'm here and ready to go. So.
And Larry, I sense not a little bit of happiness of you being here, though.
Oh, I like being here. I just don't like being here with no notice and thrown in at the last minute.
Well, let us know if you need
It's the
anything from us to
last-minute-ness
help
that's
you with.
unhappy. You said there was some violation that you had sent to Jacob. Did you send that to me, Heather?
Yep, it's in your email.
I'll start reading through that now. Thank you all.
Thank you. Josh, are you?
On the way.
I'm sorry.
I'm on my way. I'm just sitting on 94.
No, but what are you? What?
I have an in-person sentencing with Nicole Young, I believe.
I don't think so. You need to wait a minute. Hold on. We don't have sentencings today, at least in our courtroom.
Yeah, the website's all fouled up then. Because when I searched by P number, it was coming up that
it says it's tomorrow.
Tomorrow.
Wait a minute. Let me see. It wouldn't. Yeah. Is it for sobriety court?
Yeah.
Yeah, it's tomorrow. We have sobriety court on Wednesdays.
Well, hot diggity dog. I don't know how I miscalendared that. I don't think the computer screwed up. I think I am then.
Well, it's the same thing with Trovia Star emailed and said he couldn't make the sentencing either, and he was a month early.
Yeah, so actually the notice to appear had the wrong defendant's NTA on the email. So yeah, I think a few things got fouled up, but I know that they're playing shorthanded right now as well.
Right. So it's tomorrow at 9 a.m. So you're good.
All right. Well, have a great day. I'll see you guys tomorrow.
You too.
Thank you.
Mr. Roberts, you need a breakout room with Mr. Mullis?
If I could, thank you.
Yep. Let's see.
And as that court grinds to a halt, let's go ahead and move along. Say good morning to Judge McNally.
Come on up to the podium, please, and tell me your name. How are you?
Good, yourself?
Good.
Sergeant Micah Keller, Michigan State Police.
Ma'am, your name? Good morning to you. The charge here is failure to yield right of way. Was anybody hurt in this accident, Trooper?
Yes, Your Honor, it was a Brownstown Police Lieutenant. He had minor injuries to his hand for the airbag deploying, I believe his tongue.
All right, so, ma'am, this has nothing to do with the fact that it's a lieutenant from Brownstown. It has everything to do with the fact that I don't reduce these accidents if somebody's hurt in the other car. Okay, so you can either plead responsible to it, or you can go forth with the hearing if you would like.
I'm just here for forgiveness if you.
You got to keep your voice up for me.
I'm here for forgiveness if you forgive my points.
I can't do that, ma'am. When somebody's hurt, I won't do that.
It's my first time. I'm 5 years driving, so
See.
never got any.
Ma'am, I've been doing this for a long time and I've never changed or wavered in my policy here. I just will not reduce it when somebody in the other car is hurt. I'm sorry. So you can either plead responsible or you can go to a hearing.
Was my all, you know, my.
Did you hear what I said? Did you hear what I said?
No,
It's okay that you disagree with me. People disagree with me. You want to plead responsible or do you want to have a hearing?
I'm responsible.
All right, to the charge failure to yield, responsible or not responsible? You plead responsible or not responsible? I'm sorry? Okay, I'll accept the plea. Your total's 195. You can go down the hall and make that payment, okay? Good luck to you. Thank you.
Thank you.
Thank you, Your Honor.
Thank you. Have a good day. Today is the 15th, 16th. Jim. Even changes to 7th, 16th, if you can figure it out.
John, we put that one up now.
Yeah, well.
Quiana Victoria Vassar, 23F 2414110A and 23B 1444426A and 123F 2413331 and 23F 241410B and 23B 1444426B. Your name, ma'am?
Quiana Vassar.
Ms. Tucker Davis, are you on this? Who's on this? Oh, you, Mr. Westmoreland. Okay, I'm sorry. Your appearance?
Good morning, Your Honor. Attorney Cori Westmoreland appearing on behalf of Ms. Vassar.
Okay. So she just doesn't like to show up, it looks like. Would you tell me how she wishes to proceed?
Yes, Your Honor. At this time, we are prepared to waive a formal reading. My client stands mute.
I'll enter not guilty, please, on all of these for her. So let's just start by you explaining why this young lady doesn't think she has to show up in court.
Your Honor, she was living in Garden City at the time. I know that's no excuse, but her car broke down. She didn't have any opportunity to get here. I did explain to her that this honorable court does allow Zoom, so that may be a good option, but she is currently residing in Flat Rock. She is gainfully employed working at Tim Hortons. Moving forward, she knows that she needs to appear and take care of all these matters. She can start making payments next week, Friday, when she gets paid. She acknowledges that she owes the money. She's not currently on probation or parole at this time. I just ask that all that be taken into account.
Ma'am,
Yes,
I don't appreciate this.
I
Okay,
know. I apologize.
well, I hope you got some money with you. You put yourself in a horrible position now. You really did. Really did. And you got cases from 2023, and I don't want to hear this about not having a ride. You certainly were driving through these local cities and townships around here in 23 and 24. How long have you lived in Flat Rock?
I want to say since 2016.
And you couldn't get here from Flat Rock?
No.
If I'd have told you was going to give you $1,000 to get to the court, you would have gotten Woodhaven, wouldn't you, for these, wouldn't you?
Well, not to pay me. I should have tried to walk.
Yeah, I know. That's my point.
Yeah, I apologize.
Don't apologize to me. You might be apologizing to yourself if you can't come up with the money. But it's no skin off of my neck. All right. You have two cases assigned to Judge Hessen. Those are 23B144-426A and B. On that one, you owe $327, including the clearance fee at least, plus $213 for a total of $540. I'll cut it down and set a bond of $1,500, 10%, which will cover the A file and the B file. You have a case in front of me for which you owe 213, I don't know, I guess this one's also in front of Judge Hessen, 23F241331. I'll cut it down and set 1,000, 10% on that one. The drive while suspend has never been adjudicated, so I will incorporate on 410A, Lisa, I'm setting 3,000, 10%, and that will also cover the 410B file. So looks like you owe $550. I will give you the earliest court date I can. We will give you pretrial dates on the Flat Rock case for June the 18th. June the 18th at 10:45. That's this Thursday. I will likewise set the other ones June 18th. At 10:45. And the other one as well, June 18th. All these will be June 18th at 10:45. I hope you can post. They're going to let you make some calls, but you just can't do this, okay? I hope you're going to learn a lesson. I hope you can post the bond. I really do. But
I hope I can too, but I have learned my lesson.
I'm sorry?
I said I'm gonna do the best I can to post the bond, but I have learned my lesson.
Good luck to you. Thank you.
Thank you, Judge. Have a good
Thanks.
morning, Your Honor.
You too. Thank you.
Take care, Your Honor.
Good morning once again, everybody. TCF Live on this fine Tuesday. While we wait for Judge to rack up another contestant, remind you we have Sidebar tonight. Please do join us for that, 8 p.m. Eastern, 5 p.m. Pacific. Looks like Barbara just recently put a link in the chat for that, so do be sure to check us out. Well, Judge just leaned back in his chair, so he's going to be a bit. Let's move over and say good morning to Judge Simpson, I guess. Do that.
Today is the date and time set for preliminary exam. It's my understanding that people are prepared to proceed.
That's correct.
Your Honor, at this time, then the defendant will be waiving his right to preliminary exam. We have a signed and executed preliminary examination waiver form to tender to the court.
Is that correct, sir?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed?
I do.
You understand that by waiving that proceeding, you'll not have that hearing. You'll proceed to circuit court for further resolution.
I do.
All right. People also waive their right. Preliminary examination having been waived, defendant found over on all felony counts, and I think in 0403, that'd be count 1 with 2 following. And on the other matter, will be on count 1 and 2 with count 3. Mr. Burdell.
Your Honor, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all charges. Retrial in these matters will be set for
June 30th at 1:30 with Judge McBurney.
June 30th, 2026, 1:30.
Thank you, Judge. And if we may be heard as to a preliminary matter, when the court here is deems it appropriate. Mr. Hillsberg, he wants to take the accountable choices while he's in custody, but he needs court order to do that. We would ask if the court would order him to be made available for accountable choices at this time.
Any response from the people? I will indicate that the defendant is to enroll in accountable choices as part of his bond.
Thank you, Judge.
Thank you.
You're all set. Thanks, Kyle.
Pardon?
Done. You want to approach to sign information?
Yes, let me just. Left me up here by myself. No, I'm good. I can do this.
It's hurry up and stop morning in courts today, where they do one thing and then all of a sudden there's delays. Some days work like that. Let's go back to Judge Oakley, though. It looks like he might have some new contestants.
Nobody.
Who's the guy in the jail room?
Who's that?
You in custody, I'm looking.
That's Mullis.
That's Mullis?
Yeah.
Or maybe he doesn't have anybody. Like I said, it's hurry up and stop morning here at TCF Live. Let's go back to Judge Middleton, because doggone it, even if it's a story about a bridge, there's always something going on there.
Yeah. All right, the White Pigeon Village Attorney is here today, and they're not generally here on a Tuesday, but they're here for some other pretrials. So he's reviewed the matter, he's looked at your license, and he's agreed to dismiss the case. The problem is, this may happen again. You may get pulled over again, and somebody's gonna give you a ticket again. I can't tell whether those are valid or not. Neither one of the QR codes comes back to anything that I could discern. That doesn't mean they aren't valid, but I couldn't connect them to anything. There is a way to get an international driver's license. I've seen a few, mostly from Indian citizens with lawful status. I've seen some false ones also. They bought them at a grocery store in Elkhart. But your case is dismissed. You're free to go. Make sure you carry that stuff with you whenever you do drive. And hopefully we'll sort this out. But as far as this ticket is concerned, it's dismissed. You're free to go. Thank you. Now, Mr. Penn and Ms. Carpenter are supposed to be here. They're not the most dependable.
Sure, they are.
They are here? Oh, very good. So they're here. So, all right. You're free to go, sir.
Thank you.
Ms. Bakarowski, would you come back up? Mr. Timothy George is the Three Rivers City Attorney. And he gave me the authority to reduce this charge. So let's take a look at it again. You got a ticket on May 28th for leaving the scene of a property damage accident. River Street and 8th Street is where the big curve is by the dam. There used to be a bridge there called the Wood Street Bridge. We get quite a few accidents there because the curve is so sharp. They allege you were driving a
I'm sorry, I have to pause it for just a minute, because did I not just call it that there would be a story about a bridge? This is why Barbara tells me that I am the best host on YouTube. I am patting myself on the back. I told you that he would have a story about a bridge, and there it is. All right, let's continue.
2011 Chevrolet, and you crashed into a fence. And then they found you at 120 River Street and brought you back. That's a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100, and it carries 2 points. Mr. George, the city attorney, has agreed to dismiss that charge if you plead to having an accident running into fixtures. A fixture is something that's on the side of the road like a fence post. And so that carries no points. It does carry a fine of up to $100 plus costs. Are you willing to plead to that charge?
Yes, Your Honor.
Anybody threaten you to get you to do that?
No.
Tell me what happened.
I had my dog with me, and he's a golden retriever, a big dog, and he was like, he wouldn't get back, and I kept telling him, Moses, get back, get back. And then when I turned, and then I went boom, right into that thing, and that's all I remember.
Which way were you going? Toward Three Rivers?
Yes, and the reason I left, I wanted to get him off to safety and then go back to the car. I mean, I know the car is mine. I thought it was gonna be fine.
So did you go to some friend's house?
Did I notice the car?
Yeah.
Yes,
Okay.
yes. And I do have insurance and full coverage, and through the grace of God, because my car was totaled.
Oh, Jamai. I'm glad you were here. Is your dog Canadian?
Is he Canadian?
Yes.
No, no.
You said his name was Molson.
Moses.
Oh, Molson. I thought it was.
Moses, like Moses. Oh, sorry.
Molson.
Excuse me.
Molson would be a good name for a dog if it wasn't Canadian. All right. How long were you there before the police found you?
Just minutes, minutes. It was very quickly. I was planning to go back. I wanted to get somebody to tow me out of there, pull me out of there.
Well, you've made it through your whole life with no points. You're not gonna get any points for this either.
Praise God.
George, I believe that's 621. All right, that carries a $75 fine, $75 crime victims' rights fee, and a $50 state minimum fee. That's $200.
Do I have a little time to pay that?
Yes.
Thank you.
Can you pay it by the end of July?
Yes, absolutely.
I'm gonna do by $200 by 7/31/26. If you need more time, come see us. The goal is to get the fine paid.
Thank you so much.
You can just come over here and pay cash at the courthouse, or you can.
Okay.
Deputy Myers, could you give her this?
Thank you so much.
All right, Ms. Bakarowski, good luck. I'm sorry your car got totaled. I'm
Thank
glad
you.
your dog was okay,
Thank you.
even
Thank
if he
you.
isn't Canadian.
Have a blessed day.
Thank you.
Okie dokie. Barbara, thank you for the $5. Yay, Dan. See, I told you. We love you, Dan. Thanks for being the best host on YouTube. Well, thank you for your support. Nina, $5. Thank you as well. The only way it could get better is with a photo of the bridge. I'll see what I can dig up. Good news, while all that was going on, I did manage to fix things with YouTube. I found a little trick to fix it, so it actually shows us as being a live show now. 32 minutes in. Okie dokie. Back to Judge.
All right, we're moving along. Byron Rhodes.
And Barbara, thank you for $10 more. See, Dan, Nina thinks so
Oh.
too. Thank you.
I didn't catch Amanda Sawyer. She already had a 257, 326. Good morning. This is file 261007OT, People versus Byron Rhodes. Good morning, Mr. Rhodes. Mr. Rhodes comes in here because he likes coming in so much. He keeps getting tickets for driving without a valid operator's license. This one is alleged to have occurred on May 23rd, 2026 in the city of Three Rivers. You haven't paid the last one. In March, they set the matter for allowing another to violate the motor vehicle code, and you haven't paid that. It was due March 31st. Then you have a sentencing tomorrow. Anyway, let's take a look at this ticket. According to the ticket, it was at 11:30 in the morning on May 23rd, Wood Street and Michigan Avenue. All it says. Of course, Threers is a small town. If they saw you driving, they probably pulled you over. Doesn't indicate anything else was going on. You didn't show up on June 4th. Judge Pattison issued a bench warrant for $1,000. That wasn't my fault. Well, I usually don't do that. I do a show cause. Anyway, you didn't get picked up on the warrant, did you?
Huh?
Did you get picked up on a warrant for not showing up?
No. I called that, or not the day, I called on the 8th.
All right, well, they must have been.
The officer told me my court date was the 8th. It says on my ticket, it's the 8th.
All right, well, your license is expired.
Yeah, I went to get that though.
Tell me about that.
Can I show you these?
Yeah.
I don't have the exact documents. But you told me it's supposed to be on the 4th. The officer wrote it on the 9th.
Oh, well, let's see. All
That's why-
right, well, anyway, that may be, well, you're here now. The ticket says reply within 10 days.
Yeah, I didn't want a bench warrant for something I didn't know I was.
All right, well, you're here now. No, I take his, oh, yeah, you've applied to get your license?
Yes, I already got that taken care of.
All right, Mr. George, how about if we adjourn this and see if he comes in with his license? You also got to pay your earlier ticket.
No, the last time when we had court, I thought I went down and paid that too, before you guys moved everything. Remember before you guys?
Yeah, well, this says here you still owe $200, so we'll find this out. When are you going to take your test, whatever you have to do?
I'm waiting for them to tell me that something's wrong with their vehicle. I'm waiting for the next available vehicle so I can go do it right there in 300. I don't know, but I'm waiting for that to happen. I think it should be like the next 2 weeks or something like that. They should get their vehicle fixed.
I'm gonna use that same date I used earlier, July 28th. At 8:30. And I hope you pass your test.
Yeah, I got it set up for the road test.
Now, don't do this again, because you'll dig the hole deeper, and if you come in with a license.
So I try to set it up so I don't come in here for that again.
I know you like coming in here, but.
You know I like coming in here. 12 million views, baby. Of course I come in here to see you.
Yeah, all right, Tuesday, July 28th. 2026 at 8:30. Bring proof of license. And check in with the clerks on that unpaid fine. This shows you owe $200.
Yes, the last thing I paid was 200 when I did that court.
Well, it could be a mistake. So you check in on that before you go, and I'll see you on 28th, and you bring your license with you.
Yes, sir.
All right, very good. Vera Manier.
Alrighty, friends, I'm going to take us down to Florida and Judge Mercer for his first appearances. But before we go there, I have it paused. We're not going to not going to go there, but this is Judge Carnesale. She has one of the most intense games of courtroom squares going that I have seen lately. That's a whole lot of people on that screen that she's got to deal with this morning. So personally, I'll take JR's iPhone for the center square, but you guys let me know in the chat which square you want to take. Anywho, let's go to, as promised, Florida and Wade Mercer.
Mr. Johnson, good morning. Mr. Johnson, you're here for first appearance accused of one count of battery, domestic violence. There is probable cause for the charge. You have several family members here, and I believe some of them, or at least one of them, may want to be heard from. Is that right? I need his attorney to be able to hear everything you say, Mr. Johnson. So if you'll come on up to the microphone and be glad to listen to anything you want to tell us. I have read the complaint. There is probable cause. I've also looked at his criminal history, and it's his third arrest in about a year and a half. Less than a year and a half, his third arrest. The state dismissed the other two eventually. So anything you think I need to know, I'm glad to listen.
Your Honor, the conditions are worsening in their home. I am actually here on behalf of my parents who are aging. My mother's 75, my dad's 79. They don't often share the details, but when they do share the details of what's going on, I understand based on their account that conditions are worsening. And I'm advocating for my parents, asking that you do consider the entirety of the criminal history and its progression, and not to, that's basically what I have to say. I'm concerned for my parents, my sister, and my mother are in the room. I believe they're here actually in a similar mindset. And so if they want to speak, that's fine, but I'm concerned for my parents.
Is this your nephew?
Nephew.
This is your nephew?
Yes,
okay.
sir.
And the complaint alleges that there was definitely alcohol involved, but possibly some other type of illegal substance in addition to that. Is that the family's perception? There may be a drug issue, a drug abuse issue, not just alcohol is what I'm asking.
Yes, sir.
Okay. Let me see if the attorneys have any questions for you. Mr. McDaniel, anything from Mr. Johnson?
No, Your Honor.
Mr. Mitchell?
No. Can you hold up your middle finger of the one that was? Oh, she's not here. Okay. Okay.
Do you have any questions for Mr. Johnson?
No, I don't have any.
Thank you, Mr. Johnson, for being here today.
Appreciate it.
Okay. Mr. McDaniel, anything on behalf of Mr. Hayden Johnson?
Your Honor, just let the court know that he's, best of my knowledge, I don't think he's ever been convicted of a crime, and that, he'll abide by any court order if there's no contact order. Please, guys. And we'll just, ask for some kind of release option.
Okay. Mr. Mitchell?
Your Honor, given that this is his third arrest within a year's period, we would be objecting to like a conditional release or something. We're requesting a reasonable bond under the circumstances with conditions that he not allowed to possess or consume alcohol and no contact with the victim. And this, I think I might have to ask, do they live at the property? Okay, yeah, no contact with the property either.
Okay, so Mr. Johnson, what I'm going to do is the state did dismiss your last two charges. I did look at the dismissals. I read them closely, as well as the charges before that. What I'm going to do is set your bond today. You're entitled to a bond. Your bond, because of your history, is going to be $5,000 cash or surety. You have a condition of no contact with the alleged victim. You have a condition of random urinalysis, and you have a condition of no alcohol. So he's entitled to a bond. He's just entitled to one under law. Now, whether or not you or family or friend post bond for him is a different question. Mr. Johnson, you probably would be a conditional release candidate, but only to an inpatient drug and alcohol treatment center. So if that sounds like what you want to do, if that sounds like what you want to do, then typically they want you clean and thinking clearly before you commit to that kind of program. In other words, I'm not going to let you go the next morning after you get arrested if you're allegedly under the influence of something, because you make a decision, you agree to go, and then you're not even thinking clearly. You've still got drugs in your system. So if that's something you want to do, then today is Tuesday, either perhaps the end of this week, maybe Friday, or the first of next week, if Mr. McDaniel wants to bring you back up. And if you still want to go, and if there's a program that will accept you, you may be a conditional release candidate. In the meantime, you have the right to post a bond. If he wants to go to a program, the best thing may be to stay where he's at then go to a program next week and let's let him do that program and see if it helps. We're also going to give you a notice for your court date. That will be June the
9th.
June the 29th will be your court date, and that will be at 9 a.m. Now, if you're in a program on June 29th, we'll just pass your court date to another court date. I don't want him coming back from a program for a misdemeanor arraignment date. Okay. But if he's out of jail or if he's still in jail and hasn't gone to a program, well, if he's still in jail, it'll be a different date. If he does post bond, his court date will be June 29th at 9 a.m. Let me see if the family has any questions. Any questions from the family? No, Mr. Mitchell.
I'll see Miss Stephanie Colbert from the sheriff's office very shortly. I'll see if she can get out there and get them screened, and we might be able to get them back before the end of the week.
Well, help educate me here. Now, does she do that now on all cases, or does the chaplain still do them if they're in jail?
I normally go through her, but she may work with the chaplain.
Corporal, is Chaplain Pippin still coming to the jail?
Yes.
Okay.
Okay.
Yes, sir.
All right, thank you. I think your mom has a question. Yes, ma'am.
There is a drug rehab in that be.
We have a couple of conditions. Number one, it needs to be at least 6 months in length. The second condition is they have to be willing to notify us of violations. Some programs say because of confidentiality rules, they won't notify the court, and that's okay. I just don't let them go there. They don't want to tell us. It doesn't do us any good. And Chrome is one we use all the time. There's one in Promised Land. We have several that we use all the time. So as long as they comply with those conditions, and the other conditions, they have to regularly give drug tests because if they're not going to test them, it's again, we don't know if they're using it or not. So as long as it's an approved program or one that we've used in the past, if we haven't used it in the past, we certainly may approve it. I just need to know a little more information about it. All right. Mr. McDaniel, anything else from your perspective, sir?
Nothing except, Your Honor. I mean, except that he's waving his arms. He's not waving his arms to go to rehab. He's waving his arms to go take a drug test. He don't have drugs. He don't use drugs. So, but,
Okay.
I got way too drunk. Way too drunk.
Okay. Mr. Johnson, do you have any? Mr. Johnson, do you have any questions? I didn't interrupt you, Mr. McDaniel. What were you saying?
Just, I understand the court's position, Your Honor, and, but I just, still was just going to stress, the make a mild objection that with no criminal history, there is a presumption of non-monetary releases, but I understand the court's concern.
Oh, he has criminal history besides that we didn't get into. Possession of cocaine in 21, synthetic narcotics in 21.
Cocaine. I don't think that's him. He's not but 21 years old.
Okay.
22, 23.
That was it being
Paraphernalia in 21 that was dismissed.
I literally, my only charges were when I was 18.
I don't remember no possession.
No, I didn't have no cocaine or anything like that. When I was 18, I caught dope.
Well, that's what he's saying. Did you?
Sometimes it shows let's see if this is Jackson County. It is Jackson County. So let's see.
I think
21 CF. Let's see.
Could be
Is it 21? 21-560 CF. Possession of controlled substance. Let's see what the substance was.
Looks like meth.
Methamphetamine. I'm sorry. If the rap sheet says cocaine, but methamphetamine means zero difference to me. Wish you the best, sir.
Thank you.
Family have any questions? All right, thank y'all. Next case is Carvel Curry.
You want the other ones also?
Yes, please. We've got some violation of state probations. Carvel Curry, Tamisha Young, Elizabeth Whitener.
Ms. Whitener?
All right, so Mr. Curry on my left, Mr. Young on my right, Ms. Whitener in the back. Good morning, everyone. I'm seeing you at the same time because your cases are identical for first appearance purposes. Each of you is accused of violating the terms of your probation or community control, and in each case, a circuit judge has signed a no bond warrant, or a judge has signed a no bond warrant. Usually, it's a circuit judge. So what I'm going to do this morning is I want to get you arraigned. That means I want to get you a lawyer appointed if you would like to have one appointed to represent you. Mr. Curry, would you like to have an attorney appointed to represent you?
Yes, sir.
All right. And Mr. Young, same question.
Yes, sir.
All right. Mr. Widener, same question.
Yes, sir.
I'm going to appoint the Public Defender's Office of the 14th Circuit to represent each of you. Please listen to Mr. McDaniel. When he gets through, we'll see if you have any questions.
Your Honor, we're going to plea of not guilty. Ask to set these on July 9th court docket, and I advise them all that attorney will come by and visit them prior to that hearing.
Thank you. July 9th, Mr. Mitchell.
No, Your Honor.
Thank you. Mr. Curry, do you have any questions, sir?
No, sir.
Mr. Curry, wish you the best. Mr. Young, any questions? Wish you the best, sir. Ms. Whitener, do you have any questions?
No, sir.
Wish you the best, ma'am. We have Cori Hall next.
The screen.
I'm sorry.
The screen.
Ms. Hall, good morning. Ms. Hall, you're here for first appearance accused of 7 counts of child neglect. Ms. Hall, I've read the complaint. There is probable cause, ma'am. And Ms. Hall, I'm going to appoint the Public Defender's Office to represent you. Please listen to Mr. McDaniel, and we'll see where we go from there. Mr. McDaniel.
Your Honor, I've talked to Ms. Hall. At this point in time, we just asked the court to consider, I don't think she has any criminal history, some kind of conditional release. I do recognize that there are serious charges against her. We have nothing against some kind of supervised. I think her mother has kids next door now. We just asked the court to make that consideration.
Mr. Mitchell.
Your Honor, given the severity of the charges that she's facing and the conditions that were described as to what the kids were living in, we would be objecting to a conditional release. We're fine with you granting a monetary bond, reasonable under these circumstances, but we also request that she have no contact with any of the children and or comply with the DCF case plan, which it looks like there is a contact and safety plan in place.
Okay.
Say that this is, conditions are based on goes to the court, and she's being charged. It is what it is, but poor people live the way poor people can live sometimes, and we have a different standard today than we had 30 years ago, and I think we all can agree with that. As far as the children, I'll leave that to a jury to decide. But she's not going nowhere. She lives right here. She don't got nowhere to go. She'll be here for a court hearing.
The problem is it's not just poverty. That's the primary concern of the complaint is allegedly she leaves his children alone every weekend while she goes to visit someone in the Department of Corrections and leaves these 7 children alone, period. That's the problem I've got. People are, if it was just poverty, that'd be different, but the allegations are that she's done a horrible job as far as choosing to go visit some man in the Department of Corrections instead of staying home and taking care of her children. And she's obviously got money to go to DOC to see him if the complaint is accurate. But I'm not comfortable saying, go ahead, Mr. McDaniel.
I would just argue now. I don't think 20 years ago people would say you're leaving them at home when grandmother lives next door. And plus these are not, the youngest is 7, but it goes all the way up to the age of 17-year-old. One of the kids are almost 17. I don't think that's.
My mom had little ones when
I clearly had. I can just remember my kids were babysitting younger than that, 17, a lot younger than that. I had mine babysitting at 12 years old, infant. So the idea that a 17-year-old can't, watch a 6-year-old.
I don't disagree with that. I don't think a 17-year-old should be required to every weekend take care of their 6 younger siblings because their mom wants to go to the Department of Corrections and see some man in prison. So I'm not comfortable setting a separate bond in each case like I normally would because essentially it's one act. What I'm going to do is set a $5,000 bond on the first count, cash or surety, and I'm going to give an ROR on the other 6 counts because it's one alleged act. Your bond is $5,000 cash or surety. You have a condition of no unsupervised contact with your children. Now, that supervision can be approved by DCF, by whoever they approve, whoever they deem appropriate, but no unsupervised contact. If I could stop you legally from going to the Department of Corrections every weekend and seeing whoever it is you're seeing there, I would do that. I think that's a stretch under these circumstances. I don't think I can do that. I can certainly suggest to you that's not a smart thing to do anymore at all. I would encourage you to be at home on weekends seeing your children, not in prison seeing whoever this is that you're seeing there. But you've got a $5,000 bond cash or surety. You have the right to post it. You have a condition, no unsupervised contact with any of your 7 children, and we're going to give you a court date for July 7th. Mr. McDaniel, my intent is not that she remain in jail over this. I just want to keep some standards on her, and there's 7 charges. I'm not comfortable giving a conditional release with 7 charges. Having said that, if she hasn't posted bond within a week and you want to bring her back up and renew a request for a conditional release, I certainly will consider it. I'm also not opposed to a cash bond if the state and defense are in agreement with that. Mr. McDaniel, would you like to consider that?
Oh, yeah, she would consider cash. That's fine with her, Your Honor, cash bond if the state's okay with it.
Mr. Mitchell, what's your thoughts on the $500 cash only bond?
That's fine with me, Your Honor.
Okay, so the purpose of the bond is to ensure your appearance, make sure you follow the rules. It's not to keep you in jail. So I'm going to set your bond at $500 cash. Maybe a little easier for you to make than giving $500 to a bondsman, because you may get it back if the cases are dismissed. I don't know if they will be or not. And Ms. Hall, do you have any questions, ma'am?
No, sir.
All right, ma'am. Wish you the best.
Thank you.
We have Anthony Gossick. Just a second, Mr. Gossick.
All right, well, Judge gets his stuff in order. Michael, thank you for 13 months with us. Thanks, Dan, Beth, community, and Ellie, TCF Forever. Thank you for thanking Ellie. She appreciates that. And thank you for gifting the membership as well. Congratulations, as you say, Michael, to the lead singer of Yes for his gifted membership.
Case, the person not turned himself in and deal with a warrant, and the attorney not withdraw. So neither of those things have happened. So as far as our file goes, that attorney still represents you. He or she has not chosen to withdraw. But the warrant was never dealt with, so we have this old DUI to deal with. I've also looked at your criminal history. I'm aware that you've been to prison at least once in Florida. So I've looked at your other criminal history also. So I think you're entitled to a bond, but I'm going to listen to the attorneys before I make that final decision. Mr. McDaniel, anything?
Your Honor, Mr. Gossick, he works at Dothan Signs. He's been there for about 3 years. He went recently to go get his driver's license fixed in Alabama where he lives at, and that's when he found out about this, and he came up here and turned himself in. He did pay a retainer to an attorney years ago. He's never heard back from him, and he didn't know about. He thought everything was taken care of when he hired the attorney, and no one's kind of communicated anything with him since then. But he did come up here and turn himself in when he found out about it. We just asked the court to consider maybe a cash bond, and I advised him when he gets out, because his attorney has filed that notice, that he needs to contact him and see if he can't figure out what's going on with his attorney.
Thank you, Mr. McDaniel. Mr. Mitchell.
No objection to a cash bond.
Mr. Gossick, considering the amount of time that since you've known about the case, because you hired an attorney apparently, which is 3 years ago, your bond's going to be $500 cash only. You have a condition not to possess or consume alcoholic beverages and not to drive a motor vehicle unless you have a valid license. If your license is okay, you can drive all you want. Otherwise, you've got a condition not to drive a motor vehicle, and you've got a no alcohol condition. Also going to ask the jail to give you a notice for your court date for June the 29th. Well, the private, I don't know that the private, he said he's paid a retainer. So I don't know that the private attorney is going to still be on the case, but as of right now, he is. So yeah, I guess we need to put on the private attorney date for now, which will not be June 29th. That'll be July the 9th at 1:30. If that attorney gets off the case, then we'll cross that bridge when we get to it, but your court date will be July 9th at 1:30. The jail will give you that notice, and you'll get to use the phone in a few minutes to try to post the bond. Do you have any questions, sir?
No, sir. Thank you.
Yes, sir. Have a good day. We have already seen Ms. Whitener. Christopher Smith is next. Mr. Smith, good morning. Mr. Smith, you're here because you've been accused of one count of driving while licensed, suspended or revoked habitual, as well as violation of state probation in case 26-146 CF. There is probable cause for the charge. Let me listen to the attorneys, and I'm going to address your bond status. Mr. McDaniel, anything?
I don't have anything, Your Honor.
Mr. Mitchell.
Nothing, Your Honor.
Mr. Smith, I'm going to set your bond on the felony charge at $10,000 cash or surety with a condition not to drive a motor vehicle. But don't try to post the bond because I'm going to hold you 7 days with no bond. That's what I do anytime. 99% of the time when someone's on state probation, I hold them with no bond for 7 days. I'm going to ask Mr. Mitchell to notify the probation office. If the probation office seeks a warrant, we'll see if the judge signs it and whether or not you get a bond in the VOP if they do sign it. But right now you have no bond. I'll see you next Tuesday and we'll see if they have a bond, a warrant or not. If they get a warrant before then, I may see you before then. Any questions, sir? Thank you, John. Jessica Morrow. Jessica Morrow next. Ms. Morrow, good morning. You're here for first appearance, charged with 1 count of driving under the influence. Ms. Morrow, there is probable cause in the complaint, and the criminal history I've got shows no prior criminal history. So, Ms. Morrow, please listen to Mr. McDaniel. Ma'am, Mr. McDaniel.
Your Honor, I spoke to Ms. Morrow. At this point in time, we're going to enter no contest. The charges listed. The understanding should be placed on probation for 11 months, 29 days, $1,078 in fines while she's on probation. She'll take a DUI class while she's on probation, alcohol classes. If she gets signed up in the first 60 days of the DUI, that will constitute her alcohol counseling, 50 hours of community service, and minimum driver's license suspension. That'll resolve this case today. She has signed a two waiver, one waiver about the jury trial and call witnesses and a stipulation of less than 0.15.
Thank you. Ms. Morrow, did you hear that agreement?
Yes, I did. Yes, sir.
Do you have any questions about that agreement?
No, sir.
And ma'am, is that the plea that you would like to enter?
Sir.
Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Ms. Morrow, I'm going to accept your plea of no contest to the charge of driving under the influence. Ma'am, I'm going to adjudicate you guilty, but it's a plea, you're pleading to blood or breath alcohol level of less than 0.15. That's important because that removes some standard conditions that Florida statute has otherwise. Ms. Morrow, I'm going to sentence you to 11 months and 29 days probation. You will have the standard conditions of every probation plus the following special conditions: $1,078 court costs and fines. Successfully complete substance abuse counseling, ma'am. If you enroll within 60 days with the DUI program, the DUI school, that will satisfy your substance abuse requirement as long as you complete it. 50 hours of public service work. I do recommend the minimum driver's license suspension. If you choose to do AA or NA instead of the DUI school, then we're going to put a cap on it of 12 classes. That would be the number you'd have to go to. Ms. Morrow, let me tell you what's going to happen next. They're going to let you get dressed in your regular clothes. They're going to let you use the telephone to set up transportation. Then they'll bring you to the courthouse. When I say they, I mean the jail staff. The courthouse is where the probation office is at. When you get here to the probation office, Mr. Goodson or Mr. Ham, one of those probation officers will go over the terms of your probation with you. They'll give you the copies of the rules in writing. They'll give you a chance to ask any questions, and then you'll be free to leave. If you call friends or family, Ms. Morrow, you can tell them that you can be picked up probably in 30 or 45 minutes at the courthouse, not at the jail, at the courthouse, which is where the probation office is at. Ms. Morrow, do you have any questions?
I only have a t-shirt. That's what I came in.
They'll
No
have
shoes.
some more. They'll have some extra clothes out there.
You got somebody to call those?
Yeah.
Yeah,
Okay.
they'll have some extra clothes. If they don't, we'll make sure we get you some. Any other questions, ma'am?
No, sir.
All right, Mr. Morrow, wish you the best. Mr. McDaniel, as far as I can tell, that's everything on my list unless I missed somebody. Anything else, Mr. McDaniel?
Just the story once we go off of YouTube.
Okie dokie, friends. Looks like they've finished up there. Good morning once again. Now in hour 2 of TCF Live. Good to have you all with me this morning. Let's give Brian Oakley another try. They might maybe have their stuff together now.
So in no particular order, I've got the file ending in 0453, which is this top count is assault with intent.
Yeah.
That one we're going to set for an exam.
Yes, Your Honor.
And that's going to be next Tuesday. Already set. All right. So we're going to leave that on for next Tuesday.
Thank you, Judge.
You're welcome. What time is it? Council, continue bond on that one?
If we could, thank you, Judge.
Okay, done. All right, then I've got the file with the malicious use. That one's we're set for or malicious destruction. I'm sorry. We're gonna set that one for a final pretrial with the complainant to be in court.
Yes, Judge.
I don't think the prosecutor can do that soon enough for next Wednesday. Oh, it is.
I
All
think
right,
we
never
should
mind.
put it
Heather
out
just
for
told me it's the same victim, so we'll just schedule this for a final pretrial the 25th. 23rd? What did I write in the other one?
June 23rd is already.
Okay, all right.
Yeah.
And bond continued on that file.
Thank you, Judge.
You're welcome. All right, that gets us to our last file, which is a misdemeanor file. 2 counts, drove while license suspended, revoked, or denied, and registration or plates misdemeanor. I understand there's been an offer on that one.
Yes, Judge. I have spoken with Mr. Mullis. I'd ask if we could set that one over also to the 23rd.
Sure.
Mr. Mullis just expressed that may have been a refile, so I just want to look into that one a bit further before he takes an offer.
Sure. All right. No problem.
Thank
All
you.
right, bond continued on all 3 files. We'll see you fellows next week to wrap these up, hopefully.
Appreciate it. Everyone have a good week.
The 23rd. Judge, I am going to jump off Zoom to handle the matter with an attorney that's in the room
Yep.
with me, but I am next door.
Go ahead. All right. Yeah, Mr. Mullis, all 3 files have been bumped till next Tuesday.
Yes, sir.
All right.
I'll see you in the jail, Mr. Mullis, okay?
All right, thank you.
Thank you.
Mr. Mullis,
Yes, sir.
if you would, just tell the deputy we're ready for the next person.
Yes, sir.
Thank you.
Yep. Yes, sir. I'm ready for the next.
Okay, so this happens in the second and third room. I know the attorney was there for a pension, I believe it was. I sent the message to the clerk. Are you all ready to see her next?
We are.
Yes.
Okay, sounds good. Let's go.
Can I see in a breakout room, please?
Pension?
Yes.
Yeah, as soon as we get her, Miss Moss, we'll put her in breakout with you.
Okay, thank you so much.
Sure.
Have a seat to build on, okay?
Thank you.
And as always, Ms. Princeton,
Thank you, Marianne.
Well, we got one hearing out of it at least. Let's go back to Judge McNally.
Attorney John Camilleri on behalf of Teresa Vasquez, President of the courtroom.
Your name, ma'am?
Teresa Vasquez.
All right. You got a discovery order with Judge Corky's name on here.
You're much better looking.
I don't know about that.
Oh, no.
Maybe 35 years ago I was. Listen, you're gonna have to go get her to agree to it.
Yeah, I thought she signed it, but apparently.
Didn't sign it,
She did.
and you could just scratch out Judge
Yeah.
Corky's name and put mine down, and then come on back in. How's
Okay,
that?
all right.
Okay, here, Denise, you can hand it to Mr. Ian Larry. Thank you. Ma'am, you can have a seat a second.
Thank you.
Okay?
Appreciate
Thanks.
it.
No problem. Michael Alex Willoughby, 26M705074A and B. Your name?
Michael Willoughby.
You don't have a lawyer?
No.
You already met with the prosecutor?
Yes. Didn't make it today. He was proper.
You have the right to an attorney. If you want one, I will give you one. Would you like an attorney to represent you?
No, thank you.
Okay, so I'm gonna go ahead. If you want me to take this plea, I'll go ahead and take it. You wish to stand mute and waive reading of the complaint on the drywall suspend charge, and then I'll go into your plea agreement here. Is that what you want to do?
As I spoke with the prosecutor.
I know. Do you want to waive your reading, or you want me to go ahead and formally arraign you on the driving on a suspended charge? Okay. So I'm entering a not guilty plea for purposes of arraignment. Now, as I understand it, you're going to plead guilty to the charge allowing an unlicensed driver to drive with the understanding that the suspend charge and the seatbelt charge will be dismissed. Is that your understanding, and is that how you wish to proceed?
Yes, sir.
So if you plead guilty to this charge, like I said, I'll dismiss the suspend, dismiss the seatbelt charge. Possible penalties on this, allowing an unlicensed driver to drive, are up to $500 in fines, 90 days jail, costs are all those. And then I would go ahead and dismiss the suspend and seatbelt. This will not get reported to the Secretary of State. Do you understand that?
Yes, sir.
And did you sign, read, and understand an advice of rights form here today? If you plead guilty, you will be giving up all those rights, and there will not be a hearing. Do you understand that?
No, I do understand.
You have the right to a lawyer. Do you still wish to waive your right to a lawyer?
Yes, sir.
Jen, can you cool that down a little bit? It's hot in here. To the charge, allowing an unlicensed driver to drive, how do you plead?
Guilty.
On May 25 and 26, were you in control of a 2016 Chevy black in color that was being operated on I-75 near Gibraltar Road in Brownstown?
Yes, sir.
Did you allow somebody to drive that was unlicensed, and was that you?
Yes.
Are you on probation or parole?
I'm in sobriety.
Okay. Were you on probation on May 25th of 26?
Technically, no, I mean, that would be considered probation.
How long have you been in sobriety for?
7 months now.
Okay, so you're on probation though, right?
Yes, sir.
All right. So you understand if you plead guilty here, this would be deemed a violation of that probation. That probation could be revoked. You could be incarcerated on that charge as a result of this plea and conviction.
Yes, sir.
You still wish to plead guilty?
Yes, sir.
Anybody force you to plead guilty?
No, sir.
I'll accept your plea. Where are you in sobriety court at?
25th District Court, New York.
Did you get transferred over there?
Yes, from the Whitener.
Why are you driving on a revoked license?
I was offered like interlocking my vehicle. I was just getting in.
Yeah, you can't drive though, sir, without an interlock device.
I actually have a breathalyzer 5 times a day. I can not show the officer.
It's a SoberLink device, right?
Correct.
Okay, but you gotta make sure you got all that ironed out with the court and the Secretary of State. You're revoked. You can't drive. Where were you going?
Just to the one beer.
Going where?
The lake beer that day.
Tell Judge Clifton about this?
Yes, sir.
He knows? And the probation department knows? You gotta answer out loud.
Yes, sir.
All right. Can't be doing this. Anything else you want to tell me?
No, sir.
You gotta get your SoberLink, your interlock, okay?
Understood.
100 fines, 210 costs, 75 victims' rights, $50 justice assessment, 435 or 60 days. You can pay that now?
Everything.
And I'm dismissing again the suspend and the speeding. How much do you have today?
Can you $50?
I can't hear you.
$50 for now. Okay, is it payment plan?
And then how much per week?
You 25.
Where do you work?
I work at
What do you do?
front desk supervisor
Where?
at the Hampton Inn.
How much per week?
About 18 an hour.
How much?
18 an hour.
All right, you pay 50 now and pays 25 per week, and I'm gonna start that beginning on June the 29th. Okay? That's on a Monday. If you ever need more time, no problem. Call the court. We'll go on Zoom. I'll be glad to give you an extension, okay?
Okay.
Good luck.
Okie dokie, friends. Good morning once again. TCF Live, Hour 2. Hope you're all enjoying yourselves so far. Let's change it up. Let's go to Newaygo, Michigan, Judge Springstead. There is a MDOC inmate there with his attorney, and it sounds like they're doing some kind of motion to dismiss. So let's see what that's all about.
Case number 2613743 FH. Mr. Smith is here for a motion to dismiss. You can go ahead, Mr. Presa.
Thank you, Judge. Well, I submitted my brief motion to dismiss
alleging a couple of factors that I believe indicates grounds for dismissal, Judge. First and foremost is that the period of time that has expired since this case was originally held in front of the court, then a probation violation was held, and the case was dismissed at the probation violation. Our position is that the prosecutor didn't give a sufficient basis and grounds and reason for dismissing the case, proceeded with a probation violation. The court sentenced Mr. Smith to 13 months at that time, 13 months, 5 years. Then the prosecutor waited 286 days to bring a new charge against Mr. Smith. I have a document here that I picked up last week from the Department of Corrections when I went to visit Mr. Smith on Friday from the Central Michigan Correctional Facility. I gave a copy to the prosecutor, Judge, but what this shows is that on February 11th, Mr. Smith was granted parole. Prosecutor filed the charges the next day. Then on February 18th, once the Department MDOC received information that the new charge had been filed on February 13th, they rescinded his parole, or at least suspended it because of the new charges that were filed. Again, 286 days later. So the second part of our motion, first part is that since the prosecutor didn't give valid reasons for the dismissal other than, well, we're just going to proceed to the probation violation, the 180 days should have continued to run because our position is that the dismissal was non-effective and was moved. Our second part of our motion is that there is an indicia of prosecutorial vindictiveness, that they waited 286 days. He gets his parole. They filed a charge full and well knowing that Department of Corrections is then going to revoke his parole, which they did. So he's been sitting in prison. There's no, that I know of, valid reason why they waited 286 days. They had the charge. They knew they were going to file the charge again. There's no new evidence. I was involved in both of these cases, involved in the case now. There's no new witnesses. There's no new evidence. There's nothing that has substantially occurred to effectuate a 286 delay on this case. It did nothing but prejudice Mr. Smith. It did nothing but cause him more time that he has served. Granted that the new charge could have resulted in a consecutive sentence, but it also could have resulted in a concurrent sentence. And I think when you have these conflicting positions and situations, the court should review it in a light most favorable to Mr. Smith, because he is the one who's been prejudiced by the delay. The prosecutor has absolutely no prejudice because of this delay. And so for those reasons, we're asking the court to dismiss this case against Mr. Smith. Then he can proceed with his further proceedings with the parole board, Judge. Thank you. And I'm prepared to answer any questions that the court may have.
Sure.
Regarding my brief.
Do you have any case law that says that could guide the court as to what is a sufficient reason to be placed on the record for dismissal?
What was that again, Judge?
Do you have any cases that would guide the court in assessing whether the stated reason was sufficient or not?
Yes, as a matter of fact, we do. Second. We've got People v. People v. Barker, I believe, supports our position. And People v. Hall, that the 180-day rule to give the defendant the ability to defend the case within 180 days if he's part of the Department of Corrections. And People v. Ryan and U.S. v. Goodwin, it talks about prosecutorial vindictiveness, as well as U.S. v. Legault, procedural due process, which is violated when there's indicia of prosecutorial vindictiveness. And the court does have the authority and the ability to dismiss the case pursuant to the case law. Also, we submit to the court that the
hang on. I'm not asking you to recite your whole brief. I was trying to focus in on a very narrow issue. Do you have any cases where the court has said where the prosecutor gave a reason and the court said that's not good enough?
No.
Just that narrow issue is when my first question is just that narrow issue.
No case. I don't have any case law regarding that other than the, statutory requirement that the prosecutor give a reason why they're dismissing the case.
All right. And the reason given was that the defendant wanted an adjournment or the probation violation because they had a new case pending, and then decided they didn't want to wait to adjudicate Mr. Smith, so they dismissed it.
Yes, because the prosecution's basis of the probation violation was a new case. Exactly.
All right. Do you have any cases that say that they can't do that?
No.
All right. So as I understand it, your argument as to the vindictiveness was that was triggered by the granting of the parole.
Yes.
Okay. And do you have any information that says that when the prosecutor reauthorized the charges that they knew that Mr. Smith had been granted parole?
Well, the document that I just gave you says that the reason that they granted his parole and the reason they suspended the parole because a new charge was filed. So they must have known about it.
Well, that must have and actually did know are two different things. I mean, it is a strange coincidence for sure, but one doesn't necessarily lead to the other. So I'm just asking you simply, do you know that the prosecutor had that information and that's what triggered their decision to recharge Mr. Smith?
Well, all I can say is that the notice says the parole board is suspending the parole action pursuant to MCL 791.2362 to consider information received by the parole board after the original parole release decision, which is the new charge. Following is a summary of the new evidence. That is the basis for reconsideration. And then they say that receipt of the new charge. So that's why they suspended it.
Okay,
I said because they received the information.
I know that's why the parole board made the decision that they made. But the next step is, do you know, and I'm gonna ask Mr. Welburn about it, but do you have any information that says that the prosecutor knew that Mr. Smith was granted parole and that's what triggered the reinstatement of the charges?
No.
Okay.
That's incorrect. We did.
Hold on.
All right. To you, Mr. Welburn.
No, I don't. Primarily, I'm going to rely on my brief. I mean, the court's been along with us every single step of the way. They've got all the transcripts, but they were here back when we dismissed the PV. We said exactly what we were going to do. This should be a surprise to no one. The only thing is we followed through on what we said. On the speedy trial issue, Your Honor, I don't believe.
Hang on. I want to go back to the parole thing because that doesn't sit well with the court. If the prosecution decision to reinstate the charges was triggered by Mr. Smith being granted parole, that smacks of vindictiveness. So when did the prosecutor find out that Mr. Smith had been granted parole?
Judge, I can explain to you what went down. I don't know when, but I can explain to you, and I'll be perfectly honest with you about why I picked this file back up. The initial hearing where we dismissed the PV, Ms. Robinson was here, right? She does Monday court.
Yes.
She did it. She puts a note back in the file. You guys were here. I was not here again. He had appellate counsel and there was some issue. I don't know what it was on, a sentencing or some sort of issue about time. Once again, I was not a party to the case. I'm sitting in my office watching on YouTube, trying to keep track of what's going along with the files. The court made some innocuous comment about, well, they haven't recharged you. Maybe they're not going to that. Like, what is going on there? You guys close the hearing. I go pick up the file. There's a note from Ms. Robinson in the back. And preserve all evidence for Scott to reissue later. I pick up on the call. We're supposed to reissue this file. I reissue file. If you're asking me where that happened in the time guideline, I have no idea. I see a letter from the AG here dated 2/12. I probably didn't figure it out till 3:30 because I think that's the date on the complaint. If I wanted to be vindictive, I would have sat on it another 90 days because I have 180 days under the rule. I did. As soon as I became aware of it, I did the complaint. I was not trying to be vindictive. I can't tell you the precise moment, but I saw some innocuous thing while I sat in my office. I watching court on YouTube, picked up file, reissued case. I was not being vindictive. It may look that way to the court, but that's how it went down.
So what was the note on the file generated directing someone to reissue the charges?
What's that, Your Honor?
You said there was a note in the file. Was it dated when?
Yeah, it's
Ms. Robinson
dated
told you to
back on June 17th of 25.
Judge, what may help is the stenographic record of the resentencing hearing held before you on February 10th, 2026. On page 10, Ms. Robinson conducted that hearing. And on page 10, he says he has been through enough counseling, programming, and so forth that the parole board has seen fit to grant him parole. His parole date would be March 24th, 2026. So I have the stenographic record that the court could review that shows that the prosecutor knew on February 10th that he was being granted parole.
But that
he had been granted parole.
But Mr. Walburn's statement was that basically the elected prosecutor directed someone, I don't know if it was him or somebody, to recharge this in June of 2025, but apparently it fell through the cracks.
That's exactly right.
That it wasn't the decision to recharge it was made, it fell through the cracks, and then they had the appellate issue, and then they did it. So
we're assuming
one at a time.
We're assuming it fell through the cracks. Maybe somebody saw it and said, no, the hell with that guy, I'm not going to reissue it yet. I'm going to wait. So, I mean, that's the other side of the coin. Maybe they saw it and waited.
If I was going to do that, I would have waited longer, Your Honor. You're giving us, the court knows, out of sight, out of mind. Until you come back in front of the court and someone does something, we sometimes don't pick up files. That triggered me picking up the file, going back to Ms. Robinson's note, and I think I found it on 210. So I'm literally in my office watching. This goes down. Well, we're supposed to do that. Whoops, pick up file. I know it's not a great answer for the court, but the court knows we got thousands and thousands of files. Until sometimes something puts something back into our face, it is off the radar, and this brought it back in the radar. It was not vindictiveness. I didn't wait a second, Your Honor. I did it immediately. I was like, oops, let's get this going. See the letter from the AG in there. We got the case going. Like I said, we didn't wait anymore. I know it's not a great answer for the court, but as far as the vindictive, we weren't being vindictive, at all. Ms. Robinson told everybody what she wanted done back at that original. Everybody knew what was going to happen. They just didn't think we could do it.
So, I kind of look at the speedy trial thing. There's two different aspects to it. Number one, there's the charged but unresolved cases against prisoners. And there's certainly no violation there. The prosecution got the notice. We got the notice and then he was brought here and that was started. So I don't see any violation of that. But the other issue is more of the due process, right? You know, Mr. Prysack, how was in terms of being able to defend the new charges, how was Mr. Smith prejudiced by the delay?
Well, I would say regarding due process and the ability to defend, he could have, he would have defended the charges had the case been filed sooner, and possibly if the outcome had been, for example, a not guilty verdict in the court, he'd be out on parole. He'd have been out on parole because the 180-day rule would have effectively made this case go to trial within 180 days. He would have been out of, he would have been out on parole within 180 days after, when they dismissed the probation, when they dismissed the charge, went forward with a probation violation. If they had issued the new charge right away, because they knew they were going to issue it, then 180 days from that date, he would have had to go to trial. If he went to trial as a triable case and was found not guilty, he'd be out on parole. So the prejudice to him to defend the case is that he wasn't able to defend it in a timely manner, because the 180-day rule required that it be brought to trial within 180 days. So in my mind, the due process is that it was delayed, and a delay in the due process has caused him to sit in prison for much longer than he potentially would sit.
That's not really a delay in defending the case. I mean, that's not prejudice there. I mean, typically when you see, you know, a true speedy trial violation, it's like witnesses aren't available, memories fade, lost evidence, that sort of thing. Not that so in other words, I'm not seeing how any delay impacted his ability to defend the case. Now, what came afterwards isn't good. I mean, that certainly caused him problems in terms of credit and parole and stuff like that, but the ability to defend the new charges against him, how has that been impacted by the delay?
Well, okay, I understand that. I understand that. I guess the only thing I could present to the court would be if he'd been able to bring the case to trial within the 180 days. There were witnesses that he could have presented that would be fresh witnesses. Now any witnesses that he's able to present, how much time has gone by? 8 months, 9 months?
Over a year.
So, you know, then another 5 months on top of it before they bring the charge. So any witnesses that he may be able to present have now faded to the point where calling witnesses in his defense, I don't know if we can find them. I don't know where they might be. And so a delay has hurt him presenting his defense in the case. If the case had been brought sooner, then our witnesses were there, they're fresh. Now, I don't know whether, number one, we can find or present any witnesses to defend the case, and two, whether they may recollect anything that occurred, not giving away, you know, our trial strategy.
Well, you kind of have to, if you want to say that you're prejudiced by not being able to find the witnesses and the
Right.
Memories have been faded. Who are the witnesses? Have they been contacted? What would they have testified to? And has their memory faded at all?
That I don't know. I haven't talked with the witnesses. I can tell the court that the night that this occurred, Mr. Smith blacked out, was at a campground, rode away from the campground with someone driving his car, woke up in the passenger seat. That's where they found him, and the assumption was that he had driven. So that witness that we would have been able to present, we don't know where they may be at this point in time. So that's just one instance, and basically the main instance of his inability now to defend the case because that key witnesses, we don't know where they may be.
Who is it? Maybe the prosecution knows where they are.
Possibly.
Who is it?
Pardon me?
Who is the person that you say would take responsibility for driving the car?
I don't, that's what I'm trying to say, is that when I came to, there was nobody in the car, I was in the passenger seat, and I've tried, but if I was out, I could have looked at was that's another thing I want to say about as far as, when I was in Calvin, I requested that done on my car to get a fingerprint. And obviously that can't get it again with evidence now.
We don't have that information at this time, Judge. The only other evidentiary issue that has been affected by the delay is the automobile itself. There is now no potential for forensic evidence to be recovered from the automobile to determine who may have been driving the car, fingerprints or any kind of DNA analysis, because he woke up in the passenger seat. So we don't have the ability to gather that evidence and present it to the court. Because of the delay.
In response to that, Mr. Walburn?
Yeah, I don't think there's any prejudice. All the witnesses are listed in the police report. Yeah, before this case was dismissed too, I think there was a prelim exam. So there's a transcript, people were called, the stuff was preserved, and it was explored. That's certainly going to take away some of the prejudice they would have, I guess they're indicating they had. They had an opportunity to develop some of this. We have a transcript of it. That's going to exist for them to use.
I understand what you're saying.
All right, the court's going to take this issue under advisement and issue an opinion.
I think we're scheduled for, we're on the trial docket already.
Seems like it's in, seems like it's August, before August.
Yeah, the 21st, 22nd.
All right. All right, yep, fair enough. All right, that's all for today.
Thank you, Your Honor.
All right, so we're going to get an opinion.
Well, I didn't expect that he would give an immediate ruling, so that's not surprising. But I don't know. Tell me if you think differently in the comments. But it seems to me like prosecution doesn't have their stuff together, and I'd personally dismiss if I were the judge. But that might just be me. Okie dokie, let's go to Fulton County, Georgia, the land of overly modulated microphones, and see what's going on with Judge McBurney's court today.
All right, Ms. Allen, we're going to get on the record. This is position 1 on the trial calendar. It's case 23 SC 187611. State versus Compton. Mr. Compton is here in court with his lawyer, Ms. Wood. Mr. Abadi is here for the state. And on an earlier date, and good morning, Mr. Compton.
Good morning.
On an earlier date, Mr. Compton entered his plea in this case. And the state put on the record its recommendation, what it was committing to. Mr. Compton said he understood that and wanted to move forward with it. We didn't get to the sentencing piece because Mr. Yancey, who's the decedent in this case, his family didn't have adequate notice when we took the plea. And so I wanted to be sure that the state had an opportunity to have any members of Mr. Yancey's family to be present, or if they had impact statements that they wanted Mr. Abadi to share, they'd have an opportunity to do that. So, Mr. Abadi, why don't you start by stating again what the state's recommendation is in the case, And then I'll turn it over to you if there is any victim impact, anything.
The recommendation made by the state.
You may need to move the microphone towards you.
The recommendation by the state at the last hearing that we had was 20 years to serve 15 years in custody with the remainder to be served, the balance to be served on probation, Your Honor.
And that was a reduction of the murder count to voluntary manslaughter.
That is correct.
Okay, and then the felony murder was vacated, aggravated assault would merge. And so was it 15 for the voluntary plus 5 for the firearm, and that's the 20 to do 15?
That's correct, Your Honor.
Okay, that was my recollection.
Members of Mr. Yancey's family are present. His mother, and I believe it's his grandmother, are present, or his aunt. I'm so sorry if I'm wrong. But she, and I will express for her, and then she may feel comfortable making a statement. I can wholeheartedly say that she does not, their family does not agree with the resolution, and I completely understand why. But looking at the totality of the circumstances and all the facts and circumstances through the investigation of Detective Sinling with the Atlanta Police Department, the state felt this was the best recommendation and outcome. So
Balancing the risk of going to trial and not a favorable outcome for the Yancey family versus the certainty of a plea. And yes, it's a different sentence, but there's a different level of closure.
correct, and it allows Mr. Compton to take responsibility for his actions that night.
Okay. So I'm happy to hear from either or both of you. It sounds like Mr. Abate and people on his team have had some good conversations with the family where you've been very candid in an understandable way about your feelings about how this has played out. If there's more you want to share with me, I'm happy to hear that. You also may say, we've spoken our piece, but I want to make sure you have that opportunity. Okay, what I'd ask you to do is come on up to the prosecution table. If you could take a seat in the middle seat. Our court reporter is virtual, and so she needs to be able to see and hear you. Good morning.
Good morning.
So if you could let me know your name and your connection to Mr. Yancey.
Yes, my name is Latina Mitchell, Latina Mitchell. I am Beyonce's mother.
Thank you for being here.
Thank you. I wasn't prepared today to say anything, but sometimes you have to speak from your heart. Beyonce was a grandchild, a son, a nephew, and a cousin, and a friend. I don't know what happened that day or how everything went on, but what I do know is my son is okay. I'm not a big believer on, religion, but God has showed me that my son is okay. It was so hard just to deal with what I'm going through. The only person that could make me feel okay was my mother. And my mother died 5 months later. I don't know how to bear with this. I have breakdowns still. I can barely work. Nightmares. I'm trying to pull myself together and what my son would tell me to do. Sometimes I feel like I'm not even myself half of the time. When I heard the last court case with the sentencing, I heard.
When you say the last court case, meaning the co-defendant?
Yes, sir.
No, the sentencing.
Not the sentencing, the plea that was given. I heard Mr. Compton say that his girlfriend was his everything. My son was my everything. I'm glad you get to see your everything every day. Through visitation, through writing letters, even when you get out. And I would hate for someone to sit up there and not have that everything. To see that pain and that heart. a mess every day. And I have the support of my family, but sometimes you're by yourself. I mean, I have to find myself. I don't have my son anymore. I don't have my mother anymore.
Was he your only child?
He was my only son. I have a 12-year-old daughter.
Okay.
And when you're going through mental breakdowns and you can't be there for that 12-year-old, and you don't see what she's going through, it's hard that I have to sit up there every day and be faced with this opportunity to sit up here and just be okay with this. But I'm glad that God has covered me, secured me mentally and physically. Me and my family are going through it. Just losing people back to back. Holidays are not the same. Birthdays are not the same. And I have to go to a cemetery to celebrate my son and my mother. And it's hard. I appreciate the courts for everything. I appreciate you, Mr. McBurney. I'm going to get through this. I just pray that God be with you, Mr. Compton. I pray for his family and everything. Thank you.
You're welcome. You're very gracious with your words. And I want to share one thing with you, which is it doesn't have to be okay. You said that, you're just trying to make this okay. What happened wasn't okay. It doesn't have to be okay. What you want to focus on is your healing and being there as best you can for that 12-year-old, because you are still a mom. You'll always be a mom to Mr. Yancey, but you're connected with him in a different way. In a much more tactile, present way, you're connected with your daughter. And so the more you can try to heal through this, the better it will be for your daughter. And hopefully that's a motivator for you to keep moving forward. But I don't ever want you to think that for some reason this needs to be okay. No one is saying it's okay. This resolution is a way to bring closure to it in a way that can be sometimes less painful than if there's a trial and everyone's looking at pictures of what happened, and that can be even more disturbing. So I wish you the best as you continue to recover from this. You won't forget, but in a very healthy way, you already seem to be extending grace to Mr. Compton, which means you may have already gotten your arms around the anger, and so it's the grief that remains. But I appreciate you taking the time to be here and sharing the ongoing impact this has for you and for your family. I wish you the best. You're welcome. Anyone else? You don't have to say anything at all. If you do, you need to switch places so the court reporter can hear you. Well, okay. All right. Thank you, Ms. Mitchell. Anything else from the state?
No, Your Honor.
Okay. Thank you for that. Ms. Wood.
Thank you, Judge. Mr. Compton is 22 years old, Judge. He is from Atlanta. He does have family support. I'm not sure, as you know, when we took the plea, he had his significant other who was here all day. I did reach out to her, and I'm not sure if she was able to log on virtually, but he does have that support. He does have one young child with her. Your Honor, he's accepting responsibility. I know at some point in this journey, we had talked about the possibility of him wanting to go to trial and argue self-defense, because as you know, there was the co-defendant and there were other people involved. I think that would have been quite tricky.
Given the number of shots fired, I think it would have been complicated.
Yes, Judge, and so we appreciate Mr. Abadi working with us on this case. He is accepting responsibility. He has been in custody 288 days, so we've asked for that credit. And then finally, Mr. Compton had asked me, part of our negotiations, I had asked, or he wanted me to ask that the 5-year probated sentence be suspended, to be more in line with what Mr.
Chalmers?
Yes.
Okay.
But that's all.
Okay, got it. I appreciate that. Mr. Compton, you have the right to say something if you want to. You don't have to say anything at all. But in the same way that I need to hear from any of Mr. Yancey's family members if they want to be heard, I need to hear from you if there's something you want to add. You and I spoke during the plea part of this process. So we've already had some of that conversation. But if there's anything you want to add, this is your opportunity to do so. No? Okay. Well, Mr. Compton, I do find, I probably said this before, but we're going to double cover it, that there's a factual basis for your plea and that your plea was knowing and voluntary. Knowing means you've understood the things we talked about. Do you have any questions about any of the things we discussed today or last time we were together? You got to say it out loud.
No.
No. Okay. Voluntary means no one's forcing you to enter this plea. It doesn't mean that you're enthusiastic about it, but it means you've decided that this is the right way to move forward rather than going to trial, running the risk of a guilty verdict, which could result in a sentence of up to life without parole. Is it fair to say that your plea is voluntary?
Or if it's, do you feel someone's forcing you to take?
Do you feel like anyone's forcing you to enter this plea, Mr. Comp? I'm not asking if you're excited about it, but I need you to tell me that no one's twisting your arm or saying, I'm gonna hurt your girlfriend if you don't plead guilty or something like that. Is anything like that happening? No? You just say it out loud.
No.
Okay, you made it through. Ms. Wood, any objection to having someone in my office sign for you and sign for Mr. Compton on the indictment?
No, Your Honor, thank you.
Mr. Abadi, can someone sign for you? We'll do that. So Mr. Compton, count one of the indictment, murder, the state has reduced to voluntary manslaughter. I'm sentencing you to 15 years to serve on that. You will receive credit for every day you've been in custody in connection with these charges. Count two, felony murder, is vacated by operation of law. Count three merges into count one, no sentence to count three. Count four is a 5-year sentence that must run consecutive to all other counts, so it'll run consecutive to count one. It will be 5 years, and I am going to probate it. I think your situation is a little different from Mr. Chalmers, and I think giving you some connection with supervision upon your release makes sense. The only condition of probation that I'm going to impose is that if you don't do it while you're in custody, is that you get your GED. You told me you got close to graduating, this close, and I want you to finish that. So you'll need to get your GED while you're on probation if you don't get it while you are in custody. Mr. Abadi, anything else from the state? All right, Ms. Wood, anything on behalf of Mr. Compton?
No, Judge, thank you.
That's it. Thank you. And thank you again, Ms. Mitchell, for taking the time to be here.
So yeah, Austin says in the comment, dude is not showing any remorse. In my opinion, I would tend to agree with you. He's wise to take that deal, though. 15 years to serve. He's only 22, so he'll have a great deal of his life ahead of him when he gets out, as opposed to trying to risk it at trial. So strategically, he did the right thing, I think, after doing a very, very wrong thing, it would seem. TCF Live, still in hour number 2. Let's go to Texas. Say good morning to Judge Stevens. Judge Stevens, who is still muted. Go across the hallway, Judge West.
Harris. And this is cause numbers 24 DCCR 0404. Mr. Harris is charged with murder, and 19 31482 charged with possession of a controlled substance. What is the announcement?
We have a tentative plea agreement, but it needs to go through the channels before, so we just need whatever the state needs.
And Judge, the court has been patient with us with regard to his Harris County case. That was obviously resolved. Not quite what we had anticipated that resolution would be with respect to also taking care of this case. But we did bring him back. Those cases are pending. I extended a somewhat of an offer to Mr. Burbank with the understanding I needed to know some specific information before I took it above my head, which he's now informed me that would be an equitable resolution. So I just need to get a little bit of approval for that, and hopefully we can wrap it up just at the next plea setting. I mean, maybe not a definite to plead, but we're pretty close.
Okay, let's reset it 2 weeks. All right, we'll reset your case 2 weeks. Kavon Sonier.
I made a mistake on this. They've indicted him as a first. I think I put it out as a second.
Okay. Morning, Mr. Nichols.
Good morning. What we talking? Injection second. and have him divided as- Right.
No, go back. Airport.
Good morning. Are you Kavon Sonier?
Yes, ma'am.
And Mr. Sonier, you're charged in clause number 25, DCCR 1530, with a first-degree felony offense of aggravated assault with a family member. And that's from September 28th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years, up to 99 years, or life in prison. Do you understand? And I have here on the tablet a plea bargain rejection that you signed with Mr. Burbank. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty or a 20-year term in prison. You have every right to reject that offer, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. And do you understand all of that? And do you want to reject that offer and have your case set for trial? And I did make the adjustment on the plea bargain rejection from a second to a first that he's been admonished. Is there any reason to believe that that offer would change?
No, Your Honor. I know there's some questions with the complainant that he's aware of because he talks to her on the phone all the time, but the state's offer's not changing.
Okay. So you're talking to her on the phone from jail? Okay, so I'm ordering today that you are not allowed to have any contact or communication at all with Delaney. Is it Saunce? Okay, you cannot talk to her. You can't call her. You can't send her letters. You can't send messages through anyone else, period. Do you understand? If you're caught doing that, things are just going to get worse, okay? All that information will be information that a jury can hear or I can hear. Mr. Nichols will hear it. So I'm ordering you now that you are not allowed to do that. If we catch you doing that at the jail, I can order that you have no telephone and none of those things. Do you understand? Okay. All right. Go back with the bailiff. Pay set for trial.
Thank you, Your Honor.
Thank you, Mr. Burbank.
I think we had a Robert Griffin. He was placed in federal custody this past week. He may be off without.
Yeah.
I have excuse.
Yes, sir.
1 o'clock.
Yes, sir.
Is it 1 o'clock? 1 for
One. Mr. Eckhart, you have Timothy Bessard.
I do, yes.
Morning.
Morning, Judge. You're not gonna say good morning?
Already did.
He's already been up here.
My first one's good for me.
He's always got to show off.
Here, call him for you.
Very far.
Good morning. Are you Timothy Bessard?
Yes, ma'am.
And this is cause number 26 DCCR 0276. Mr. Bessard is charged with aggravated assault with a deadly weapon. And 26 DCCR 0600 charged with murder. And what is the announcement?
Judge, I talked to Pat this morning and we have discovery, we have media. However, we are still waiting on a number of different lab reports. And for sure the murder, and I think maybe also the aggravated assault.
Okay.
Specifically DNA.
Okay.
And so I think we're kind of at a spot where we need to kind of stall a little bit until we get those reports in and get the files in.
That's correct, Judge. We're working on some things.
Okay. Any idea of?
I don't know, but I'll look into it and see if they can step it up or anything.
Okay, if you'll, yeah, obviously since he's in custody, if you'll take a look at that, we'll reset it so that you guys can work on getting that DNA, those results back, and then we'll see where we are. We'll do about 45 days, but if you'll check on it, see if they can kind of bump it up if possible, that'd be great.
I will, Your Honor.
Thank you. All right, you
Yeah,
go back to
listen,
bailiff.
thank
Thank
you,
you.
ma'am.
See, Mr. Eckhart, you have Robert Trahan, 3 cases. Let's get, well, he's got 2. Dalton Batiste also, or just switch on whichever.
Judge, I found another case in that case, if I'm not mistaken. I don't know if the court has defined the admonishment to get on it. I think there was accumulation.
On Trahan?
It's in the enhancement.
Yeah, I'll do Trahan real quick, and then Batiste as soon as that one's done. All right, sir, you Robert Trahan?
Yes, no.
And Mr. Trahan's cases are set for trial to begin with jury selection next Monday. There's 3 cases. We've got 25 DCCR 1094 charged with unauthorized use of a vehicle, 25 DCCR 1317 possession of a controlled substance, and 25 DCCR 1536 charged with evading arrest or detention with the use of a vehicle. And what is everyone's announcement?
You first.
State's ready.
We're ready. Judge, I do have, I was special set in orange on a bond case. So I don't know how you want to handle that, but I was special set before this case was set.
Is there a protection order or it was just a setting? But they're on bond?
Yes,
In whose court?
Townsend.
Talk to them and we'll go from there.
And I
But
have a
if
pretrial in that court tomorrow. So if whatever happens here, if I know before tomorrow. then
yeah,
I should-
you'll know the number today of your case. And so it looks like the state, well, Mr. Coleman, which case would the state elect to proceed on?
The evading judge.
All right, so 1536 would be the numbered case. And it looks like the state has filed a notice of intent to introduce extraneous. Is that just for punishment or is it any enhancement?
It's for punishment, Judge. The indictment has already enhanced this case to 25 to 99, if I'm not mistaken.
That's correct.
And the
And
state.
it looks like the previous plea bargain rejection, when we were here in March, was for 7-year term. Is that correct?
Yes, Judge.
And so, Mr. Trahan, there's only a couple of cases left set for trial, so it's very likely that yours will be close to the top of the list to go to trial next week. I want to make sure that's what you want to do, understanding that if you're found guilty and if those prior convictions are true, that you would be looking at a minimum of 25 years in prison up to 99 years or life.
Yes, ma'am.
Okay, and it looks like the state has also filed a motion to cumulate, which means you've got 3 cases. They're all from different offense dates. And so if you're found guilty on one, then we could go to trial on the next one. If you're found guilty on that one, the state could ask that any sentence you get, if you're found guilty, be stacked on top of each other in all of these cases. Do you understand that as well?
Yes, ma'am.
Yes, sir.
And not to get into the facts of the case, have no doubt Mr. Hickard has gone over the video with this defendant, but Judge, it's captured on video.
And have you looked at the video?
Yeah, it's a misunderstanding.
Okay, I just want to make sure you've seen it, y'all discussed it, and so we will number the case. I'll number it as soon as docket's over, and we'll let you know so you know what to do about next week as well.
Thank you, Judge.
All right, thank you. You can go back with the bailiff. Mr. Gertz on Dalton Batiste. Oh, shit. No, I just cussed.
All right, little foul mouth from Judge West as she mutes herself. Let's go back across the hall to Judge Stevens. Looks like he has unmuted himself.
This is 26 CR 425, the state of Texas versus Leila Clumbage. And you were here with Mr. Adams, your attorney, and the state's attorney. And once again, for the record, you were charged with a 2nd-degree felony of assault on a peace officer. By striking the officer with a purse, it was signed. And this indictment alleges a 2nd-degree felony again, which means you are facing up to 20 years in prison. And it's not a wise idea to strike a police officer who's in doing their job. I'm going to reset this for an announcement. And please get a resetting. Anything else we state?
Nothing further from the state, Judge.
Okay. Cebrito Hippolito. It's almost limes. What's the name that rhymes?
It does.
Sigfredo Hippolito.
Hippolito, and he is here.
He certainly is. That's you, sir?
Yes.
Okay. And Mr. Adams is your attorney? Oh. Are you still at 13034?
I should know.
Okay, I need your new address. That was Knollcrest. You've moved. I mean, we got to keep up with you here. Because you were just indicted in April. They would have used your address that you gave them in April. So you moved recently?
Yeah, because I'm working here in Barker, project for Beckle. So I just.
So that's where you're living now?
I'm studying.
Okay. Give me the address then.
25 City Circle Porch, Texas.
25 what?
C.
C is in Charles?
C is in Charlie, but you see Circles, Porch, Texas. I'm renting a room there.
Is that a room number?
It's a house, but I just rent a room.
And what's the zip there?
Yeah.
Zip stuff?
776
Oh. Okay. You were charged here with the third-degree felony of evading arrest or detention with a motor vehicle on or about February 14th, 2026. That would have been Valentine's Day, I think. But it doesn't end there. We, all defendants charged with criminal cases, the factoring that goes in on determining what is the punishment is based upon the crime and circumstances of the case and criminal history. And I don't have to tell you, you've got 2 convictions here in October of 2022, felony convictions of assault on family members out of the 185th District Court of Harris County, Texas. So what that means is if you were found guilty of this first crime, and if these 2 other allegations are indeed proven true, the third-degree felony bumps up to a second-degree felony punishment because you get punished more for subsequent crimes. So you could be looking at up to 20 years in prison on this case. So it's serious. So you want to make sure you heed the advice your attorney gives you. And it's going to be set on the announcement docket.
Yes, sir.
Okay. And what else? Do we need anything else to do in this case?
That's it.
State, anything to sound in on?
Nothing further from the state.
Okay, please get a resetting. Ricardo Kelly.
He's here. There you go. Tomorrow.
It's an announcement. Though.
Yes, Judge, on his case.
Ricardo Kelly.
Ricardo Kelly, yes, sir.
And state jail felonies.
Right.
Here. This seems like that's fixable, but
yeah,
I don't know.
The way I think it could be fixed, Judge, is that it involves the Avis rental car, and I think in the value they had at the car is $24,282. To my understanding, what might be a fix with district attorney's office is them getting that car back. I think that's well. I don't think
You're correct.
It's right. It doesn't.
Well,
it's so
they don't. Where's the car?
Well,
who was in his position? But it was it? Explain like that.
This is the one that's.
Oh, it was a rental, right?
Yeah, he's supposed to get the car.
This was a rental.
Correct.
October 30th, 31st, going on 3 years ago. It's still being rented?
No. Nobody said it's rented. I know.
Well, they don't have the car back?
I don't believe they have the car back.
What the heck is that all about? Where'd the car go?
Okay, the thing is, I put the car renting it for someone, and they did bad with the
That's your problem, too.
Yeah, but I'm not going to say that if I didn't do nothing with the car.
No. You rented it from rental.
That's my fault for putting my name on it.
Yeah, well, that's your responsibility when you write. That's a deal, a contract you made.
But
you're subject to being responsible for it. You just don't then subcontract them away. That's your problem. That's why they indicted you.
I'm not taking it.
The other guy may be in trouble too, but this was your response. When you sign your, you make a deal, you make a contract. And that means under the law, you're held accountable.
And I believe.
That's a lot of money.
Was get the call back from the person who actually took possession of the car.
When would that happen? We're talking 3 years ago. The loss of value is, I mean, he's got all kinds of problems here. There's no way it's the same value. It's lost its value over 3 years of use. But I don't think they're going to be happy about it. I mean, these generally, oh, it's Avis. Well, they're not letting that slide.
But I didn't want to put it on trial because the reason why I didn't want to do that was.
No, it's 3 years old. Langston, we got to move it one way or the other now. Where are we going to go? It's 3 years old. This is stalled. It's getting aged. It's too old. It's fish or gut bait right now. What are we going to do? You're mumbling. I can't hear you, sir.
I'll take the 5 years probation to get this out.
He said he'll take.
Where's the car?
I don't know. The other person did something with the car. That's what I'm saying.
Well, you're going to have to do something though to help the police and Avis get that thing. And that's going to be a condition, if you're on probation, that's a condition of your probation that you 100% cooperate with the authorities to get that darn car back.
And that's fine.
Okay. Well, that's the right thing.
1 week with him in home this one, and I'll work because I think it's not going to be a trial. I'm positive about it. To talk with him about, and then I can get with y'all.
Okay, 1 week good for everybody?
Yes, sir.
We'll reset this 1 week and see if we can move it next week with, and just kind of get all the plans in order of what he's going to need to do to cooperate as a term of probation. I want that because he's got a responsibility to help out and get that, do what he can to get the vehicle back. And then that person, do you even know where that person is?
Yes. I'm in contact with the person trying to keep them in the company.
Well, what's the problem? Well, it's been 3 years.
Something shady about it. That's what I'm saying.
Oh, you think? Are they a friend of yours?
It's a friend of mine.
What kind of friend is that? You're stuck. You stuck you.
And that's why I'm trying to get them stood down.
I wouldn't be.
My name.
Who's still a friend?
No.
That's not the definition of a friend. You look at the dictionary. All right, get a resetting 1 week.
Just hold it. We'll make it help.
Matthew, show up. Yeah.
So personally, friends, whenever I hear the name Avis, I kind of chuckle inside now. Because a few years ago, Seth MacFarlane, creator of Family Guy, amongst other things, made a show called The Orville, which was kind of an ode to Star Trek, and honestly better Star Trek than Star Trek is now. And there was an alien species there who were devoutly religious, and the name of the god that they worshipped was Avis. And that's the only thing that comes into my head now. Okie dokie, let's go back. Let's go back to Fulton County, Georgia, as we're solidly in hour number 3 here now, and the next contestant in front of Judge McBurney.
Let's get on the record, please. This is position 14 on our trial calendar, State versus Jason Bates, 25 SC 003518. Mr. Bates is here, so we'll have better sound with his lawyer, Ms. Cabrera. Ms. Smith is here for the state. And Mr. Bates, my understanding is you're prepared to enter a plea in your case now.
Yes, sir.
Okay. Ms. Smith will put you under oath, ask you a bunch of questions. You've heard what they are because we just did this with another client of Ms. Cabrera, so this will be fairly similar. Please answer the questions to the best of your ability, and please let me know if you have any questions of your own, okay?
Sir.
All right, Ms. Smith?
Mr. Bates, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can lower your hand. Please state your true, correct, and legal name for the court.
Jason Cornelia Bates.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Man, I might not be feeling up the part, but I'm still all right.
Meaning you're not feeling well?
Yes, sir.
Okay, but you feel like you can go forward with this process?
Yes, sir.
All right, if you need to take a seat at any point, let us know.
Yes, sir.
How old are you and how far have you gone in school?
On to the ninth grade. I'm 43.
You're how old?
43.
Are you able to read, write, and understand the English language?
Not as well like that.
If you need anything explained, let me know.
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, no.
And are you satisfied with her services?
Good.
Counsel, are you satisfied that your client has a full understanding of this proceeding? Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea? Mr. Bates, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants? No warrants.
No warrants.
Okay. Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years probation?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
I think you go back over that again.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering this guilty plea?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Bates, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 25 SC 003518, how do you plead to count 1, aggravated assault, count 2, possession of a firearm or knife during the commission of or attempt to commit certain felonies, and count 3, receipt, possession, or transport of a firearm by a convicted felon?
Guilty.
You say,
Yes, ma'am.
okay. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you also understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
All right. Thank you, Mr. Bates. Your Honor, if this case were to proceed to trial, the facts would show, my apologies, that on November 2nd, 2024, officers of the Atlanta Police Department was dispatched to 205 Harwell Place, Northwest Atlanta, Georgia, 30318. That's also in Fulton County. They got a report about a person being shot. When they got to the incident location, they went to an apartment complex that was owned by the victim in this, or rented by the victim in this case, Ms. Cardwell. When they got there, they noticed shell casings in the parking lot and the bullet hole in the upstairs apartment unit, Unit B, that was being rented by the victim in this case. The EMS forced entry into the apartment where they found upstairs Miss Joyce Cardwell. She was lying between the bedroom and her bedroom in the hallway. She had a gunshot wound to her stomach. She stated to the officers that there was a fight going on outside. So this is an apartment complex we're talking about. There's a fight going on outside. She looks out the window, and while she looks out the window, she hears a shot. And before she knows it, she's the one that has this gunshot wound to her stomach. At this time, she was alert, she was present, and she was taken to Grady Hospital by EMS. After she was taken to the hospital, the officers then did an investigation where they found out that 2 of the people that were fighting in that parking lot was the defendant, Jason Bates, and also Ricky Hightower. They were arguing about, I don't know what it was about, but at that time, Mr. Bates took out a gun and tried to fire at Mr. Hightower. However, it missed Mr. Hightower and shot Ms. Cardwell, or it went through her window and she was shot. The state got a chance to speak with Mr. Ricky Hightower, who was incarcerated at Fulton County in this case, where he told us and confirmed that it was Mr. Bates that he was arguing with that night, that it was Mr. Bates that took a shot at him, missed it, and it went through Mrs. Cardwell's window where she was shot. In this case, I spoke with the victim, Ms. Cardwell, who said that at this point, she just kind of wants the case to wrap up because it's been a very long time. She said that she is still sometimes dealing with back pain, fatigue, and things like that. She told me that she's kind of older, so a lot of these things come with age, but also it's worse than because she did get shot. She said that she does not know Mr. Bates. She moved out of the apartment complex after this, and she has not returned since. I did talk to her about the probated offer in this case. It was encouraged by her because she wanted the case to be resolved. She does not believe that Mr. Bates intentionally tried to shoot her because they don't know each other, and she knew that he was trying to shoot someone else. However, she wants him to take accountability for what happened. So with the facts and circumstances of the case, and also with the talking to the victim about what a resolution would look like in this case, the state is offering 10 years of probation for the charges we have in this case. Regarding the special conditions of probation, the state is asking for the defendant to stay away from the incident location. It's my understanding that he had maybe a godmom or grandma who lived in that apartment complex. I'm not sure if she still lives there. However, we would ask for the defendant to stay away from the incident location. We will also ask for the defendant to have no contact with the victim. Again, she does not believe that he knows who she is. However, through discovery and learning her name and possibly someone else knowing her from the complex, the victim in this case would ask for no contact. We're also asking for the defendant to complete an anger management course and 40 hours of community service. And that is all from the state, Your Honor.
All right. So Ms. Caldwell or Cardwell, she's okay with not more jail time for Mr. Bates.
That's correct.
And Mr. Hightower, I know he's not listed as a victim, but that's who Mr. Bates was trying to shoot.
Yes.
He's okay with this.
Well,
You may not have asked him
When I went to speak with him, he just kind of told us about what happened that day.
what the
not
deal was.
What he felt about jail time for Mr. Bates.
Okay.
And to add on to that, Your Honor, we had previous conversations where custodial time was the offer that was given in this case. Back in February, the case was on the trial calendar where we
To continue it because the
continued.
detective wasn't available.
Correct. But during that time, I have been speaking with Ms. Cardwell, and her biggest concern is to have to come to court to testify, to go through the trial. So she said this resolution is something she's okay with because she wants the case to wrap up. And she would just hope that Mr. Bates will take accountability and not get into any more trouble over the next 10 years.
Okay, got it. And Ms. Harvey from pretrial, tell me about Mr. Bates.
Yes, Your Honor, 33 cycles, convictions from 2022 for aggravated assault, simple battery, family violence, possession of a Schedule I controlled substance, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon. 2020, possession of marijuana with intent to distribute. Also, 2020, sale of cocaine and sale of a Schedule II controlled substance. 2020, possession of a firearm by a convicted felon, possession of a firearm during the commission of a felony, possession of cocaine with intent to distribute, possession of MDMA, possession of a Schedule I or II controlled substance. 2012, possession of cocaine with intent to distribute, and 2001, aggravated assault. And nothing further to add, Your Honor.
That was plenty. Thank you.
You're welcome.
Ms. Cabrera.
Yes, Judge. I'm asking that Your Honor accept the plea as negotiated. He has mental health issues. He could have some physical issues, ulcers and other stomach issues. He is in the process of starting therapy at a program down on Edgewood, where he will receive counseling. With his stomach issues, he's often admitted into the hospital. So whenever he goes into the hospital for the ulcers or anything, he's admitted. So that was one of my concerns as it relates to community service. I'm just I don't want to set him up to fail the community service. But that was my concern, and I did speak with the state about that. So she actually did cut the community service hours by what she initially had requested. There are bipolar issues and things like that he's managing. He is on disability. While he was in custody, he lost a disability, so he is going back through the process of getting back onto the disability that he had. He has children, he has grandchildren. He's supported here today. So I'm asking that Your Honor accept this plea as negotiated. I do not know that he is eligible for any sort of behavior incentive date. If he were, then I would ask for that, but that's what I'm asking for, Your Honor.
All right. Mr. Bates, how many kids do you have?
I got four. I got four children. I got 2 girls and 2 boys, and I got 4 grandkids.
It's a good collection. Are they local?
Yes, sir.
Tell me, are you taking medication now for any mental health diagnosis?
Well, I'm starting my I'm starting it up. What the word I'm looking for? I'm starting
Have you used to take the medication?
Yes, sir.
And then you stopped?
Yeah, I got to start out back over with my disability and all that.
Okay, so without the disability, you cannot afford the medication?
Yes, sir.
What were you taking before?
They had me taking Seracryl, and they had me taking some Hound Dog.
Well, yeah, the names don't matter to me so much as for what were you taking them? What did the doctor say you were taking it for?
Bipolar and schizophrenic.
Okay, but right now you're not taking that medicine.
No, sir.
Do you feel like you're understanding what we're doing?
Yes, sir.
When's the last time you worked?
Last time I worked, it's been a minute.
Okay. And where do you go on Edgewood for therapy? What's the name of the place?
It's right downtown. Yeah, I don't know. I can't recall it.
But you know how to get there?
I know how to get there.
Okay. And where are you staying these days?
Well, I'm staying with my fiance, her friend.
Oh, but what part of the city is that?
Fulton County.
It's in Fulton County. Is it in Atlanta or?
In Atlanta.
Okay. What neighborhood is it in?
It's on the west side. It's on west side.
Okay. How long have you been engaged?
I've been there at least about 4 months now.
It's a new relationship.
Yes, sir.
How'd you guys meet?
Well, my fiance, she been knowing her friend for a little minute. So she she rented us a room now.
Okay. How do you know Mr. Hightower?
I don't really know. I know him because of my girl.
Okay. And what were you guys arguing about?
We want to argue with him and another dude named Brian were arguing.
Okay. And how'd you get mixed up in that?
I don't know how I get mixed up in that, sir. I guess because, cause on down the line, I was trying to defuse the wedge. I was trying to defuse it,
but it wasn't me, it was the other guy who he thought it was me, but I was trying to defuse the fight what they were going at it with.
Okay. Do you have any questions about anything we discussed?
No, sir.
All right. Well, Mr. Bates, I find there's a factual basis for your plea. This is a real tragic situation. We're lucky Ms. Caldwell wasn't more seriously injured. I know you weren't aiming at her, but when you pull the trigger, you don't control where that bullet goes. I mean, hitting Mr. Hightower wouldn't have been a good thing either, but Ms. Caldwell didn't have anything to do with anything. She's minding her own business and you shot her in the stomach. Well, I find there's a factual basis and that your plea is knowing and voluntary, meaning you've understood what we talked about, and that no one's forcing you to enter this plea. Do you agree with that?
Yes, sir.
Okay. Ms. Cabrera, do you authorize someone in my office to sign the indictment on your behalf and Mr. Bates's behalf?
I do, Your Honor.
Ms. Smith, can someone sign for you?
You're good.
All right. So Mr. Bates, here's how I'm going to handle this. Count one, I am sentencing you to 5 years to serve 3 months with the balance on probation. You've already served the 3 months, so you get credit for that time. Count two is 5 years. It has to run consecutive to count one. I'll probate that. And then count three will be 5 years to serve 3 months with the balance on probation. That'll run concurrently with count one. So it's a total sentence of 10 years to serve 3 months, balance on probation. It's a long time of probation. I am not comfortable with just the 3 months in custody. I think this is a low recommendation. I understand why it is. It doesn't mean I have to embrace it. So I'm adding a special condition of probation. You are going to have 10 weekends in jail where you turn yourself in on Friday and you get out on Sunday. It's not going to, well, it'll start this Friday because this is only Tuesday. So you will on Friday the 19th. Let me just finish and then you can talk with your lawyer about it.
Yeah, sir, they really have been allegedly, overwhelmed for me. I'm really playing get to somebody and do those, sir.
So I'm reacting to all the things I heard. Aggravated assault with drugs and gun in 2022.
Same thing too.
Marijuana, cocaine, back in 20, gun, drugs, 12 drugs. So,
I think his desire is to explain to you all the other cases.
yeah, that's not helpful.
It's irrelevant.
Right. They are what they are. They are with you. They are part of your profile. There are great things about you. You're a dad, you're a grandfather, you're engaged. Hopefully you're going to get your benefits back. That's why I was initially inclined to say, you know what? I think you got to go back in custody for another 3 months. So total 6 months because you already did 3. But when I heard you're trying to get your benefits back, it's not going to help if you're locked up for 3 more months. You also need to get back on your medication. So I'm not interfering with your weekdays, Monday through Friday. But for 10 weekends in a row, you're going to turn yourself in on Friday, you get out on Sunday. That doesn't interfere with your ability to get your benefits back, doesn't interfere with any of that. If you'd prefer to just do 3 straight months, we could do that instead.
When they start, sir?
When does what start?
The weekends.
I was going to have it start this Friday. You want to wait 1 weekend?
I'll wait 1, yes, sir.
So have it start next Friday? Okay. So it'll start the 26th. And every Friday then for 10 weeks, you turn yourself in, they process you out on Sunday. So next Friday we'll do that. That's special condition 1. Number 2, what's the name of the apartment complex there? Do we know, or we just say Harwell Road? Do you remember the name of those apartments?
Yes, sir.
What are they called?
Dogwood.
Say that again?
Dogwood.
Dogwood?
Yeah.
Does your godmother still live there?
No, sir.
Good. You're going to stay away from the Dogwood apartments on Harwell Road.
Ran away from them.
Good. Keep doing that. You're going to do that for 10 years. No contact with Miss Caldwell. That's easy. You don't know her. She doesn't know you.
I can speak something to my lawyer.
Yeah.
About good behavior.
What about them?
When you said good behavior, sir, like,
Well, I asked Judge about that. He was inquiring about the behavior incentive day.
We'll get there. So no contact with Ms. Caldwell. You're gonna need to do 40 hours of community service, and you're gonna need to do those within the first 6 months of your probation. Not 5 years from now, but first 6 months of probation. And you'll need to complete an anger management course. That may be part of the kind of therapy you get at Edgewood. You may be able to do that all in one, and I'm fine with that. I am also going to set a behavioral incentive date for you of June 17th of 2030. That's 4 years from now. That means if you have stayed out of trouble, no arrests, you're doing the things you need to do, because I need to add one more condition of probation, and that's that you take all medications that are prescribed. So if a doctor says, take one of the things you mentioned, Seroquel, you got to take it. It's not an optional thing. So if you're prescribed medication, you got to be taking that while you are on probation. If you've done the things you need to do and we get 4 years under your belt, no new arrests, we can close this case out early. You'll be 47 by then. You should be done getting in trouble.
yes, sir.
Maybe you and your fiance will have settled down. But life is complicated. Hold on one sec. I know you've had some run-ins with the police before. You've been arrested 33 times. I'm hoping you're slowing that down going
Yes,
forward.
sir. I was just finna say, I haven't had no conviction since I've been out.
That's good. And I noticed that. That's good stuff. And it's another reason why I'm all right with just these weekends. I don't want to interfere with your therapy, your recovery, your family, but you're going to be away from them for a few weekends in a row. And to me, that balances these things out a little bit. I think so. I think that makes sense based on what Mr. Bates has said he's been treated for in the past.
That's specifically though. I forgot to mention.
Yeah.
He asked for that.
Okay, so we're going to shift up your probation officer, so it's someone who is going to be more supportive of the treatment you're getting, okay? But that means Mr. Bates is on probation now. Do we need to work through any revocations there, or that's?
He had a revocation in May of last year before he was filed.
Okay, got it. Then we don't need to worry about that. So Mr. Bates, you may be on probation for 2 cases. It'll be one officer. That'll be someone who helps you make sure you're staying current with your therapy and your medication, all that kind of stuff. Anything else, Ms. Smith? Ms. Cabrera?
Nothing further, Judge.
Do you have any questions, Mr. Bates, about what we talked about?
No, so about the, how long would that weekend be?
So you turn yourself in on Friday. If you show up at 3 on Friday afternoon, you get out 3 on Sunday afternoon. If you show up at 6 on Friday evening, you get out at 6 on Sunday evening. They keep you for 48.
Okay,
Okay?
that'll work with me.
Hope so. Don't miss any of those weekends.
I won't.
Because probation will reach out to me and then I'll say, I need to give you some straight time. And I know you don't want that.
No, you've been foul a lot.
All right. Well, good luck with things, Mr. Bates. Ms. Simpson is going to talk with you about your reporting instructions, okay?
Yes,
So you can step outside. Don't leave until you've spoken with Ms. Simpson, okay?
Yes, sir.
All right.
Thank you, Judge.
Thank you.
Okay, friends, so I like Judge McBurney overall. I really do. I think he's a fair person. I think he's fairly even-handed. You know, he listens to both sides, all that kind of stuff. This one I just don't get. This dude had 33 previous cycles through the Georgia court system. He gets in, he's a felon, so he's in possession of a firearm. That's a problem. He gets into a fight with somebody out in a parking lot, tries to shoot that guy, misses, hits some random lady in the stomach, and he's getting off with 10 years probation and a few weekends in jail. I don't get it. Makes no sense to me. I mean, I get what the judge is saying about how he's got these things that he's trying to do and whatnot, and he doesn't want to interfere. He interfered himself when he made those choices to do those things. And we know from the stats that we've run through countless times on this channel that the odds of this guy making it through 10 years of probation are slim. So we're just delaying the inevitable, and now the question is, who does he hurt next on the way to the inevitable? Disagree, let me know in the comments, but that's how I see this one. Let's go to Lake County, Ohio, Judge O'Donnell.
Thank you, Your Honor. We're present in case 26 CR 782, the State of Ohio versus Jonathan Williams. The defendant is present, represented by counsel, Attorney Dan Williams. We're present today for the purposes of an information hearing. It's the state's understanding that the defendant is prepared to waive his right to have this case presented to the Lake County Grand Jury and plead guilty to a one-count information, that being theft, a felony of the 4th degree. We would request that this be referred for a pre-sentence report and victim impact statement prior to the time of sentencing. There is a joint recommendation for community control sanctions, and the defendant is aware the state will be requesting restitution in the amount of $58,257.21. Thank you.
All right, Mr. Williams?
Yes, Your Honor, that is my understanding as well.
Okay, Mr. Williams, how old are you?
42.
How far did you go through school?
I graduated high school.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
Yes, sir.
Have you ever been diagnosed with or treated for any mental illness?
Depression and anxiety.
Are you being treated currently for that?
Yes, sir.
And are you prescribed any medication?
Yes, sir.
When did you last take your medication?
Last night.
Okay, what did you take?
Prozac.
Does that affect your ability to understand what's going on here today?
No, sir.
Did you get a copy of the information filed in this case?
Yes, sir.
Do you have any questions about it?
No, sir.
You understand you have a right to have your case presented to the grand jury for them to decide whether or not to indict you. Do you understand that?
Yes, sir.
Did you discuss that right with your attorney?
Yes, sir.
Are you going to waive that right?
Yes, sir.
All right, go ahead and have him sign that, Dan.
For the record, Your Honor, I have witnessed Mr. Williams sign the waiver of indictment. I have also signed that document and then handing it to the prosecutor.
Your Honor, I've witnessed Mr. Williams and his attorney both sign the waiver of indictment. I've signed it myself and I'm returning it to the court.
All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Williams some more, let me know and I'll give you more time. Do you understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they would be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, sir.
You still want to plead guilty to this charge?
Yes, sir.
You understand by pleading guilty, you're fully admitting your guilt to the charge.
Yes, sir.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
Theft is a felony of the 4th degree. It carries a maximum prison term of 18 months and a maximum fine of $5,000. Do you understand that?
Yes, sir.
Do you understand that if a prison term is imposed on this case, you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yes, sir.
If you are placed on post-release control and violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. You understand that?
Yes, sir.
If the violation is a new felony, you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, sir.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 18 months. Do you understand that?
Yes, sir.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
You understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer.
Yes, sir.
Have you had enough time to talk to Mr. Williams before pleading guilty today?
Yes, sir.
Has he discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice that he has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions at this point?
No, sir.
All right, Ms. Tuttle, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this case proceeded to trial, the evidence would have shown that between the 1st day of June 2023 and the 4th day of May 2024, the defendant was employed as a bookkeeper for LBL Printing in Paynesville, Lake County, Ohio. In the course of his job, he was supposed to put the cash deposits from the company's earnings into the company's bank account. Over the course of that time, he did not put cash deposits into the bank and instead kept them for himself and or deposited them into his own bank account. The total amount of the loss to the company was $58,257.21. Thank you.
All right, Mr. Williams, anything to add to the facts?
Nothing is the facts at this time, Your Honor.
All right,
Thank you.
Mr. Williams, did you hear what Ms. Tuttle said the facts would show if the case went to trial?
Yes, sir.
Are those facts true?
Yes, sir.
What is your plea to theft, a felony of the 4th degree?
Guilty.
All right, Mr. Williams?
After he pleaded guilty that we went over and the judge just went over. For the record, Your Honor, I have witnessed the defendant sign the written plea of guilty, and I've also signed that document.
Your Honor, I witnessed the defendant and his counsel sign the written plea of guilty. I've signed that as well, and I'm returning it to the court.
All right, Mr. Williams, is this your signature on the written plea of guilty?
Yes, sir.
Did you sign it voluntarily?
Yes, sir.
Do you want me to accept your written plea of guilty?
Yes, sir.
I'll accept the written plea of guilty. Defendant was present with Mr. Williams, advised of all of his rights, been a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. Will accept the plea of guilty and find the defendant guilty of theft, a felony of the 4th degree. I'll refer this for a pre-sentence report and a victim impact statement. Sentencing will be July 23, 8:30 a.m. I'll set the bond at your own recognizance with the condition of no contact with the victim. Mr. Williams, if you do not show up at the hearing, that would result in another charge of another felony of the 4th degree for non-appearing. Do you understand that?
Yes, sir.
All right, anything else, Ms. Tuttle?
No, thank you, Your Honor.
Mr. Williams?
Your Honor, just as far as bond conditions, in terms of travel, Mr. Williams is a Lake County resident. He does have some work in Cuyahoga County in between now and the potential sentencing date.
He can leave the county for purposes of employment.
And then there was also a family reunion in Ottawa County, which we were requesting consideration for the court to permit him to attend that.
He can go to that.
Thank you, Your Honor.
Alrighty, friends, a few more minutes of TCF Live, but before we go to another court, I wanted to thank Raul for giving me $20 via Venmo. Thank you so much. And he also sent me this lovely postcard, which I'm holding up to the camera the other day. So thank you for that as well. It says, "Good day, Dan. Thank you for all the wit and joy on your channel. You've fostered a friendly place to hang out. Enjoy the day. Cheers, Raul." So thank you, sir, for your kindness and your generosity. I very much appreciate it. Let's go to Judge West. We will finish our day there.
Good morning, sir. You're live in Stratton.
Yes, ma'am.
And this is 19-33601. Mr. Stratton is charged with capital murder. And what's the announcement?
Judge, we have gotten, I think, all of the media, but we're having a wrinkle with one of the police reports that's rather lengthy that Ms. Molfino is trying to figure out why it's not transferring over from the old program.
Okay. Other than that, though, everything has been.
Other than that, I'm missing about 20 or 30 pages of police report. Other than that, I think we're good.
And what we're doing, Judge, is somewhat equivalent to kind of a reverse manual bait stamp, if that makes any sense. With it converting from workflow to Odyssey, and there was all kind of glitches, including the media. We have recreated that from originals at the police department. But maybe that some of it is merged into one another, but myself and an intern are going through it this time and just documenting every single page number so I can get that to Mr. Rappert and he can tell me which 20 he's missing, because just I'm missing 20 out of the 2 red wells I had. It was difficult, and I wanted to, of course, have everything, but I think we've probably exhausted all of our discussions regarding the judge and are headed to the trial docket.
So is there any reason to believe that those pages out of that police report would change the position?
I don't know, but I doubt it, but I don't know.
So here's what I want to do. I'm going to give one more reset for an announcement.
Okay.
If the case is going to trial, I want to try it before the end of the year. So we're getting already halfway through the year. So we need to start looking at some dates and what's available if possible before the end of
I'd
the
like
year.
to get a special setting judge. I have some out-of-state witnesses that.
Yeah, no, it's going to definitely be, I think because it's the nature of it and we'll definitely make sure that when it's set, it will be the case to go. We'll do a protection order if you need it and things like that. So we'll make sure everybody's available. If you have any other cases that are set that are going, that are specially set, kind of maybe start an email with me, you guys, and we can start coming up with a date. Obviously, if something happens before then and it's taken care of, that's one thing. But if we want to start looking for a date, let's go ahead and start looking for that now.
I guess we can, after we get the next reset, we can have a pretrial conference in chambers and get some dates.
Yeah, I mean, just start an email.
Okay.
And we'll start it that way. And
Because I have so many family members, I will reach out to them now and kind of take a look. If obviously with the age of it and the witnesses, et cetera, it's a lot of moving parts.
it is a
I'll try
lot.
to
So
get
that's
it.
why we need to get it set so that everybody can get everybody here and subpoenaed, and we don't, we can't. It's going to be difficult for everybody to be completely available, but if they know ahead of time and they're under subpoena, then they won't have a choice. So I'd rather do it that way.
I do have a trip planned out of the country for Thanksgiving.
You'll just make sure you have that
I'll send that to him.
vacation letter
I
in.
will, I'll follow.
Okay. All right. So let's just do 30 days. That way you guys can please get the police report. If that changes anything, we'll know then. Otherwise, between now and then, let's start looking at other dates, but we'll have one more announcement.
Yes, ma'am.
Before trial.
May I be
Okay.
excused?
Yes. Mr. Parker, you have Darius Rigsby. Morning.
Morning.
It's an aggressive.
Well, it wasn't meant to be. I did that to Judge Davis one time. I went back and clapped my folder. He was back there and I didn't know it, and it bounced. He thought this father had a heart attack.
Good morning. Are you Darius Rigsby?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
You know, Your Honor.
Mr. Rigsby, in cause number 25 DCCR 1089, you're charged with a state jail felony offense of unauthorized use of a vehicle from May 18th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Rigsby is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 12 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with me. All right, good luck to you, sir. Can you go back with the bailiff? Andrew Howard. Andrew Howard.
Plead no one dismissing the other bill.
Good morning. Are you Andrew Howard?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
No, Your Honor.
Mr. Howard, in clause number 25 DCCR 0742, you're charged with a state jail felony offense of fraudulent use or possession of identifying information from April 18th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Mr. Howard's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal as part of this agreement in clause number 25 DCCR 0741, and this will also run concurrently with your federal case. Now, as long as
They've already been sentenced over there, and I think we're good with that.
okay, I just
I've
want to make
explained
sure.
to him that.
Well, I'm going to make sure I explain it too. The federal system does whatever they want. So I'm going to say that this runs concurrently with their case, but that's completely up to them. Okay, so it sounds like it's going to be no problem, but If it's for some reason the federal system says it's not going to run concurrently and you have to do one before the other, there is absolutely nothing I can do about that other than what I say today and what the intention is, okay? So that case is 1:25 CR 56. And as far as I'm concerned, it will run at the same time, okay? I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir.
Thank you.
Okie dokie, friends. That brings it to a close for this morning. We will, of course, be back tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, so do please join us for that. Barbara just put a link in the chat a moment ago, and the stream will take you there once I conclude it so that you can set your notifications. And, of course, we'll be back tomorrow, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. The wisdom I leave you with today from Winston Churchill: success is not final, failure is not fatal. It is the courage to continue that counts. We will see you all soon. Go have yourself a great day. Take care. God bless.